Hi everyone, thank you so much for coming today. I'm actually floored at how we're almost out of chairs at the 9 a.m. panel. I really appreciate you. And I really appreciate my Virginia Law and Business Review Symposium team for helping us get to this point. Abhaya did a wonderful job making the posters. Maddie made all of the name tags and printed all the posters, and Martina has been my best buddy, doing everything, running around with our like chickens with our heads cut off. And Tony helped get all of our fundraising. The reason we have firm merch outside, please take as much of it as you want, by the way, but it's because Tony did such a good job securing funds for this to all come together last semester. So she started working on that a long time ago. And thank you so much to our speakers who have traveled from a really far distance, some of you, to make it here on time, and a couple are still on their way. Hillary, who's doing our keynote, is gone on a red eye from California last night and was arriving at Dulles this morning at 6:30 a.m. And she's going to drive from Dulles, so I promised her a lot of food and a lot of coffee. But yeah, welcome to our ESG Symposium, Legal Perspectives of ESG, Scholarship, Business, and Private Practice. So this morning, Professor Jaffe is going to be moderating our ESG and Scholarship panel, and we have speakers Sarah Hahn and Professor Sarah Hahn and Professor Michael Vandenberg. So Sarah Hahn writes at the intersection of corporate law and democracy on subjects such as corporate governance, shareholder voting rights, and disclosure. She is currently on leave from Washington and Lee University School of Law as a visiting professor of law at the University of Virginia. Professor Hahn's scholarship has appeared in the Stanford Law Review, the Yale Law Journal, the Northwestern University Law Review, and other leading journals, and has been featured in the New York Times, the Harvard Law School Forum on Corporate Governance, and the CLS Blue Sky blog. Her article, Corporate Governance and the Feminization of Capital, which was published in the Stanford Law Review, was chosen as one of the 10 best corporate and securities law review articles of 2022 by peers in the field. Professor Hahn received a law degree from Columbia Law School, where she was an articles editor of the Columbia Law Review. And then Professor Michael Vandenberg is an award-winning teacher and scholar whose research focuses on working with interdisciplinary teams to explore environmental governance, environmental behavior, and climate change. His research has developed the concept of private environmental governance and explored how private governance initiatives can address polarization and other barriers to climate change mitigation. His interdisciplinary work with Vanderbilt's Climate Change Research Network focuses on the reduction of carbon emissions from the household sector, and he is one of the top 25 law professors in the U.S. based on peer-reviewed literature citations. He was also selected as a 2022 to 2024 Carnegie Fellow to study climate polarization. Professor Vandenberg, along with Professor Sarah Light and James Salzman, has recently published Private Environmental Governance, which you'll see on the front table outside, the first user-friendly and comprehensive guide to innovative private environmental governance approaches, which are newly accepted and powerful environmental policy tools. Professor Vandenberg graduated from our own UVA Law School in 1987, where he served as VLR's editor-in-chief. He clerked for the Honorable Edward R. Becker, U.S. Court of Appeals for the Third Circuit, then worked at Latham and Watkins in Washington, D.C., where he became a partner. He then served as Chief of Staff of the U.S. Environmental Protection Agency from 1993 to 1995. So please give a warm welcome to our panel one speakers.
We just call it and then we'll take questions.
That's perfect,
Great.
Yep.
So there's not much for me to say here. I'll just get us started off. So I'm Cale Jaffe, professor here at the law school. Thrilled to have both Professor Hahn and Professor Vandenberg talk with you all. The topic obviously could not be more timely. You all probably saw BlackRock. The state of Texas withdrew $8.5 billion out of BlackRock over protesting ESG investment. The SEC's corporate disclosure rule is now in litigation, with litigation now all consolidated in the 8th Circuit. So it's hard to imagine a hotter topic right now in the environmental space. So with that, we'll start with Professor Hahn, and then she'll pass off to Professor Vandenberg, and we'll save time for your excellent questions. So, Sarah, it's all you.
Good morning. It's such a pleasure to be here. Thank you to the Virginia Law and Business Review for inviting my participation. Let's see. Okay. So I am Professor Sarah Hahn. I am teaching a section of corporations at UEA this semester. I am a scholar of corporate governance, and my writing has focused on the expression of power through corporate governance, through corporate law and securities law. And I'm going to talk today about the ESG backlash, and I think what we're going to see is the backlash is a prime example of how corporate law and securities law are not really ideologically neutral, right? And how the politics behind the power balance between shareholders and managers, is at the center of this debate about whether ESG factors can and should be considered by investors when they make investment decisions and voting decisions. So I'm going to focus in particular on the legal backlash to ESG. So I think as probably many of you know, the ESG movement was really building momentum for a number of years and was successfully pushing companies to make various kinds of reforms through private ordering, through market mechanisms, and then we start to see pushing the wrong button to advance my slides. I will always push the right button. We start to see a well-funded, shall we say, backlash to the successes of the ESG movement. That was different. Hang on. That's better. Okay, so we start to see this this well-funded backlash, and so arguably, a catalyst for the backlash was in 2021 when a small investor, engine number one, successfully got 3 climate-friendly board members on ExxonMobil's board over ExxonMobil's opposition, right? And so in some ways it looks to me like that kicked off a powerful pushback by business. And so the backlash actually has quite a few moving pieces. So I'm going to talk today about state laws, new state laws that are restricting how investments, what factors can be considered in the state's own investments, state investigations and lawsuits against asset managers on consumer protection grounds, state lawsuits against the Department of Labor's 2022 rule allowing retirement plan administrators to use ESG factors in their investing decisions, federal investigations of asset managers in a probe to uncover whether asset managers are colluding in violation of the federal antitrust laws when they seek to do something about climate change. ExxonMobil's lawsuit against one of its own shareholders, a series, of course, of challenges to various securities disclosure rules, and then, of course, I'm going to talk about California's climate risk disclosure rule and the big kahuna, the SEC's climate risk disclosure rule. Okay, so focusing first on state laws. Last year, really, in 2023 is when we started to see state legislatures enacting statutes that narrowly try to cabin the factors that can be considered by the state's own investment funds. And in fact, in basically last year, 14 states passed such statutes. And so a good example is Florida's. So Florida's HB 3 restricts the state's own investment officers to solely pecuniary factors when they make their investing decisions. So in other words, when they choose what investments to put the state's money into, but also for voting, so voting of shares. This is part of the issue that I am particularly interested in because I'm very interested in shareholder voting. And they narrowly define pecuniary factor here as a factor that has a material effect on the risk or returns of an investment based on appropriate investment horizons consistent with applicable investment objectives. And notice, of course, at the bottom there that they exclude consideration of any social, political, or ideological interests. And so interestingly, although there are 14 states that have some variation of this new law, there are also a few countervailing states, 4 states that have adopted laws that actually require their state investment officers to consider ESG factors in the same types of decision making. And so an example of that is Maryland's statute, which mandates that its state fiduciary consider the potential systemic risks on the impact of climate change, right? And mandates that they engage in, what we call direct engagement with corporate managers, and of course that they use these factors in proxy voting. So it's really interesting that you see this sort of disparity or this sort of breakdown happening where it's required by some states and forbidden in a lot of other states. And we see where this takes us. The states, in addition to enacting these kinds of laws, have also aggressively been investigating asset managers. And so the first sort of group of these investigations focused on possible allegations of consumer protection violations. And so let me just show you here a letter. This is a letter that state AG sent to a whole bunch of asset managers suggesting that if they were marketing their funds as passive funds, that this was somehow deceptive and fraudulent because they were in fact not passive, because they were, if you look at the bottom there, pressuring companies to reach zero commitment, one of the most radical active investment strategies imaginable, right? So first there are subpoenas sent to all the asset managers. The asset managers have to undertake all the expenses of responding. Then in December 2023, so very recently, the state of Tennessee sued BlackRock. And, So they are alleging that BlackRock, this lawsuit is playing out in state court, but they're basically alleging that BlackRock has been engaged in fraud by falsely conveying that its funds don't consider ESG considerations, and also by, this part I think is particularly interesting, by overstating the extent to which ESG factors bear on companies' financial performance. So that issue will be litigated in this case, which I think is super interesting. I don't have any updates on that case. It just is recently filed. Obviously, BlackRock feels targeted by a lot of these lawsuits. This year in its Form 10-K, BlackRock, for the first time, disclosed ESG risk, or really the risk of the backlash, as an important risk that it was facing. So now this is on its 10K. And we also know that BlackRock has increased tremendously the spending that it has been engaging in on lobbying and campaign finance. BlackRock has had to kick it up quite a bit because they're really worried. And as you'll see, they continue to be targeted in other ways as well. So the states, so in addition to passing these laws and then investigating asset managers, and we'll see if more asset managers will be targeted with similar lawsuits. It may be that BlackRock's not the only one. It wouldn't surprise me if other states were going to sue other asset managers. But the states have also been challenging the Department of Labor's 20 2022 rule that was a change, honestly, to a Trump-era rule that had tried to restrict the use of ESG factors in retirement plan administrators' decision-making. And so I just wanted you to see the list of states. So the main lawsuit here is State of Utah v. Walsh, right? But about half of American states have signed on to this lawsuit. There is one other lawsuit actually pending in Wisconsin. In September of 2023, believe it or not, the Northern District of Texas upheld the Department of Labor rule, but it has now been appealed to the Fifth Circuit. And so the Fifth Circuit, as we'll see in my presentation, is the Fifth Circuit is the place where many of these important ESG challenges are being heard. They will be the decision maker, I think, in a lot of different areas. So in addition to this front of the anti-ESG backlash here, right, here are some details. They're alleging that it oversteps the Department of Labor's statutory authority and that the rule is arbitrary and capricious. Those are the legal arguments. There has also been a rash of federal investigations of asset managers on antitrust grounds. So the asset managers are getting it from a number of different angles. At least 24 organizations, including BlackRock and State Street, received requests from the Judiciary Committee, right? Here is a letter sent to Vanguard Group, right, alleging potential antitrust violations by entering into agreements to decarbonize assets under management and reduce emissions to net zero. So this has not yet coalesced into a lawsuit. This is still just demands for information that these asset managers have to respond to. In December, so just a few months ago, that a House panel specifically subpoenaed Vanguard and Arjuna Capital. And I want to focus on Arjuna Capital just for a second. Arjuna is a Massachusetts asset manager that is fairly well known for being an activist investor. They are an investor who was sued by ExxonMobil after they brought a climate change shareholder proposal this year at ExxonMobil. So in a really aggressive move, ExxonMobil sued its own shareholder, alleging that they had brought this shareholder proposal improperly. Arjuna, which is run by Natasha Lamb, who's a person who's actually featured in some of my scholarship. She sort of has this interesting track record as an activist. Arjuna Capital actually then withdrew their shareholder proposal in response to being sued, right? I think activist investors, shareholders are suddenly worried that they will all be targeted by these kind of lawsuits by companies that have a lot of resources to pursue them. ExxonMobil is very big and Arjuna Capital is very small. They withdrew their proposal saying, oh, you know, we're worried that this is going to have a chilling impact on shareholder activism. But ExxonMobil has refused to drop its lawsuit. So even though the shareholder proposal is gone and Arjuna Capital has been arguing in court that the case should be over and has accused ExxonMobil of intimidation and bullying, ExxonMobil is continuing to pursue this lawsuit. So Arjuna Capital's shareholder proposal, which of course then it withdrew, brings us to the next front in the ESG backlash, which is the backlash to shareholder proposals in general, right? So there is now pending a Fifth Circuit challenge, a facial challenge to the shareholder proposal rule on constitutional grounds. So the National Center for Public Policy Research originally brought a lawsuit, and the National Association of Manufacturers intervened in the lawsuit to try to defeat the entire shareholder proposal rule, Rule 14A8. I actually, full disclosure, have written an amicus brief in this case. There was oral argument at the beginning of March, so we don't know what the outcome is going to be there. One of the judges on the panel in this case is the same judge who participated in staying the SEC's new climate risk disclosure rules. So there's overlap even among the judges there. And the argument is that the shareholder proposal rule essentially allows investors to hijack the corporation's own speech in violation of the First Amendment, right? So I argue in my amicus brief that it's a misunderstanding of what the shareholder proposal rule does. And there are challenges to actually all of these SEC and state securities regulations. So the shareholder proposal rule we just talked about. The SEC stock buyback disclosure rule was also challenged in the Fifth Circuit, and the Fifth Circuit threw it out, but not on constitutional grounds. The NASDAQ's board diversity disclosure rule is really interesting because it is a comply or explain rule, and it was upheld by a 3-judge panel in the Fifth Circuit. However, in February, the Fifth Circuit said that it would rehear the case and bank. So we actually are going to get probably that case originally the NASDAQ won on the ground that it wasn't a state actor, so the court didn't reach any of the constitutional claims. So when the Fifth Circuit rehears the case, I think everything is back on the table, so we may get a consideration of the constitutional issues. And then, of course, while we were all waiting for the SEC to promulgate its final climate risk disclosure rule, California got a little impatient and just went ahead and created its own state law, which was immediately challenged in federal court in California. So those cases are now pending. And now that brings us, I'm sorry, this is just, it's like a net, I could go on and on and on, so many angles of attack, right? And then, of course, the SEC's climate risk disclosure rule proposed 2 years ago, right? Numerous comment letters. I wrote a comment letter myself. The final rule was just promulgated in March. It really pulled back from the original proposed rule, right? So in particular, the proposed rule had called for disclosure of scope 1, 2, and 3 emissions, and the final rule doesn't call for disclosure of scope 3 emissions. The California rule does. So the California rule that exists now goes farther than the SEC's rule. So there's an interesting conflict there. And as I'm sure you've heard, and there was an allusion to this, it was immediately attacked. These are just slides that sort of highlight how the final rule is a little bit narrower than the original rule. Just hours after the final rule was adopted, the states were back in action trying to challenge it, filing a challenge in the 11th Circuit, and there were challenges filed actually in 5 courts altogether. So there is a conservative challenge on the ground that the rule is arbitrary and capricious, an abuse of discretion, violates the First Amendment, et cetera, et cetera. Interestingly, progressive groups have also challenged the rule. So the SEC is getting it from both sides. So the Sierra Club has a lawsuit, the Natural Resources Defense Council has a lawsuit. That one is particularly interesting to me because the Natural Resources Defense Council has been suing the Securities and Exchange Commission since the early 1970s. You've got to give them credit. And so, just to kind of draw some of this description to a close here, the Fifth Circuit did step in and stay the SEC's rule, so it was, barely, the ink was barely dry on the page when it was stayed, and now it's all been consolidated in the Eighth Circuit. So that one, I guess, is not going to happen in the Fifth Circuit, so that's kind of interesting. And so, all of this leads to some questions about the impact of the backlash. There are lots of people suggesting that the backlash has been so intense and so costly, really, to asset managers and investors that they're starting to change their behavior, and that this is going to really kill or hobble the ESG movement. I don't know if it's premature to say what the result is going to be. I think a lot is going to depend on these various lawsuits and their outcomes, including especially whether the Fifth Circuit throws out a bunch of mandatory disclosure rules. Personally, in my own research, I've written about how it's super problematic for the courts to judicially construct securities markets by telling investors what information they can and can't have. And in particular, I My view is that markets are democratic in the sense that they allow investors to engage in self-determination by deciding for themselves what information they care about and what matters to them, what investments to make, what things to say to corporate managers. The state needs to be really careful about dictating to investors about this. But we'll see if all of this backlash becomes a lever to defeat shareholders and in some ways re-empower corporate managers in that age-old conflict between shareholders and managers. And I'll stop there. I went way over time, I'm sorry.
I'll see if I can switch the slides. Thank you, Sarah. That's great. I've already got a ton of questions.
You should just be able to click next, Professor.
Oh, I should.
It's all on the same deck.
Yeah, I think it is
Oh,
in one
nice.
deck.
But not with there. I need
Right, you
This
have to
thing.
push on the keyboard.
the keyboard. All right, awesome. Here we go. All right, so while Mike is coming up, I'll just say, I'll give a shout out to his great book, which if you're in the environmental law clinic, we'll read excerpts of it. Maybe we'll have an ESG case to work on next year. And speaking of clinicians, Sarah, I really want to read your Fifth Circuit amicus brief, so we'll follow up on that later. All right.
And the comment letter to the SEC too.
Oh, yeah.
Great. So thank you so much, and
All right, I can't ask more questions if I don't
Yes.
take more notes.
it's really exciting to be back at UVA, and I was taught environmental law here in the early Paleolithic era, and my professors were the then dean, Dick Merrill, and Ken Abraham, both of whom I just had the greatest respect for. And environmental law was taught as a subfield of administrative law. It was about constitutional authority for the federal government and states to act, the cooperative federalism that emerged in the 1970s through statutes, and the range of different ways you could file complaints on regulations if you were at EPA, which I was afterwards. How do you draft regulations? How do you enforce them in federal courts? And I think that was entirely appropriate in that era. But if you're still being taught environmental law that way, I think you're being taught the way environmental law was when I went to law school. And what you're going to see from me today is something about a new book that I just have out with Sarah Light at Wharton and Jim Salzman at UCLA, which suggests that there's a new version of environmental law. And what we teach at Vanderbilt is environmental law 1 is public environmental governance, which is what I learned here. Environmental law 2 is private environmental governance, which is what this event is all about. And so what I want to do is walk you through a little bit about essentially the intellectual foundations for why I think that's the appropriate way to go. And we have some of our later speakers today from the private sector too. Right, and so my other market for this book is I think ultimately, we're going to want to retrain a lot of lawyers as well who have been taught like I was. Environmental law is one thing, and then they'll get in practice like I did. I was a partner at Latham & Watkins. I represented Goldman Sachs. Len Youngkin was a client. I represented Carlyle. I did transactional work, none of which I'd been taught in law school. And I found that that influenced corporate behavior in lots of really important ways. So my hope is ultimately, if I were to come back 5 years from now, you would have a second course, or in your public environmental law course, what you would do is find every time you learn about a public phenomenon, you'd learn about the parallel private one. And I'm going to walk you through that in a second. So the first thing to do is don't get caught in the mental model of thinking about environmental law as just a public law field. Right? And how do you do that? Well, one thing is you don't let the theory dictate the practice when the practice has emerged beyond the theory. And we do that in environmental law scholarship a lot. And I love the quote from the Nobel Prize winner, Eleanor Ostrom, if it works in practice, it works in theory. And what you're going to see me doing with this book and the book that Kel Jaffe just showed you is building a theory now that a practice has emerged that the theory didn't predict. And asking, well, why did it emerge? And what does it matter to me? How should it affect how I get taught and how I practice? And I love the physicist Feynman. The first principle is that you must not fool yourself, and you're the easiest person to fool. And what I find is that people have a mental model. They ask, well, what can government do when it comes to environmental law? But once you've asked that mental model, then it's very, very hard to think about what the other potential solutions might be. Professor Jaffe and I have been talking about the potential role of pushing the medical sector, which is between 5 and 15% of global carbon emissions, to decarbonize itself, right? Are we going to regulate the medical sector? Not a chance. Not a chance in most states. Maybe California, which seems willing to regulate a lot of things, but not a chance in most cases. Might we induce public pressure to induce the medical sector to commit to the Science-Based Targets Initiative called SBTI, which would induce them to reduce carbon emissions at a rate of to get to a 1.5C future? Yeah, that's a possibility. That's a possibility. So there's an example where if we can get outside of the mindset of seeing every piece of data as simply confirming what our current mental model is, and fooling ourselves into thinking that's the only way to think about it, we can actually think very differently. And I think you all, and again, as a UVA alum, I hope you will, be the one at the table who says, is that the only way to think about this? Where can we go? Is there a different way to think about this? And that's what this book is all about. And I love this quote from the 9/11 Commission. It wasn't that we lacked the data to predict what happened on 9/11. The commission said we had the data we needed. We lacked the mental model. We had a failure of imagination. We couldn't put the pieces together to enable ourselves to think about what was actually going to happen. It was that failure of imagination that was the problem. And it also existed with the captain of the Titanic, who couldn't imagine anyway that the Titanic would hit an iceberg and go under. It was the strongest, biggest ship of its day, right? So my view for you is simply, don't be Captain Smith. Be the different person who thinks outside the box. So, this book is the one that I have out with Sarah Light and Jim Salzman. This book is the leading supplement. Some of you may have used it. Have any of you used this book in environmental law? It's the leading supplement, the best-selling one in the whole series. Jim Salzman at UCLA, Bart Thompson known as Buzz at Stanford. And so notice that these two look pretty similar. That's not by chance, right? We're trying to stay within your mental model and say, look, you need to think not only about public governance, but private governance as well. Now, how out of sync are we in our standard mental model? This is the first sentence of this book, the leading book in the field many of you will have had, and it reflects the way my field, environmental law, thinks about environmental law. The simplest definition of environmental law and policy might read the use of public authority to protect the natural environment and human health from the impacts of pollution and development. I think of much of what you heard about the pushback for the initiatives that Professor Hahn just talked about is that we're making a mistake, right? We are assuming that it is public authority that is environmental law. And now if it is, we're number one, right? Why are we number one? That's the stack of the code of famously complex tax code on the left, and that's the environmental rules on the right. So if it is just a matter of public authority, we're doing a lot of regulating out there. My argument to you is, though, once we use the word public authority, we've now defined the field in a way that limits what we can think about happening in the future, and much of the pushback you're seeing is to the recognition of that. And if you get out of that mental model, again, you will be the one who can think differently. And to do that, we've got to not start by assuming that environmental law is the exercise of public authority. And I'll give Jim Salzman credit. He's the author of that sentence, and he's a co-author on this book as well. So why worry about any of this? Notice that nothing in the pushback that you heard Professor Hahn talked about said anything about what the future might look like. And here are the various different largely public governance initiatives trying to stop the growth of carbon emissions and the increasing warming of the earth. Have we bent that curve down? No, we haven't. So my view is that the reason that we're seeing the investment community 80% of the largest firms in the world are imposing environmental requirements and supply chain contracts, as you'll see me say in a minute. Why are we doing all that? Well, people realize that we're not winning. And yet this is a dispositive problem. It's something that you want to be able to tell your great-grandchildren you were on the right side of in the future. So let's talk a little bit more about that. The good news is that the US and the EU have actually leveled off and are starting to go down in carbon emissions. The US is below 2005 levels already in carbon emissions, and the EU is as well. A challenge is that China has far surpassed the US now, and India is on its way to doing that. There need to be ways that we think about bringing the whole globe down at a much faster rate. And the challenge is public governance isn't achieving that. So why, again, think about private governance? Aren't we just disrupting the ability to adopt new federal statutes by inducing people to think, oh, there's a private option here. Well, these are the major statutes that were adopted since 1970 for major pollution control statutes, Clean Water Act, Clean Air Act. It's what you study in environmental law. And notice what happens in 1990 here. And so what's going on? Well, one answer might be I became the EPA chief of staff right about here, and we just shut the whole system down. We just couldn't figure out how to make it work. That's a joke, by the way. I know it's a little early. What I do in my environmental law class is I just raise my hand when I tell a joke because I have a real problem getting people to laugh. And then I feel better about myself. And my students kind of go, okay. So, but something happened here, right? And if you're not thinking about environmental law and the response of the private sector to environmental law by acknowledging that, you're missing something. So what happened, right? Well, I would argue that this explains much of it. This is a graph from the book that Professor Jaffe just mentioned. Here are the votes on major environmental statutes by the Democrats in blue, House and Senate, and the Republicans in red. And notice what happens at the time that this shuts down, right? The Clean Air Act amendments of 1990 were supported by a Republican president, pushed by a Republican general counsel, somebody who's actually suing to stop what's going on now, ironically. But what you see is this great divide opens up, and that's a partisan divide. So a lot of my work is with a grant from the Carnegie Foundation or Carnegie Corporation to try to understand political polarization. So I would argue that in a democratic society structured as ours is structured, we can't actually get major pollution control statutes. Ironically, there would be an exception to that. Well, what's the biggest piece of climate legislation in your lifetime? See, the Biden administration is so bad at promoting itself. It's the Inflation Reduction Act, right? It is the biggest piece of climate legislation in our lifetime, maybe that we will even have in the future. Why is it not in my graph here? Well, because it's not a pollution control statute. We've moved from an era in which we can tell polluters you can't do that, or we can price pollution, that's called polluter pays, to a beneficiary pays era. We are now able to subsidize good behavior even if we can't say no to bad behavior. Why is that true? Because of that partisan divide. We don't have that consensus. And the filibuster rules don't apply to reconciliation bills, so you can push money through Congress even though you can't push statutory requirements through Congress. So there's that divide. Climate is one of the most polarized issues in the country. You can see that from what's going on. California and New York and other states pushing hard to do more about it. Other states, including my own, litigating to try to stop that from happening. So one of the things that you see a lot, and you'll learn very likely in environmental classes, is it's just a matter of getting some more information to people. And once we get enough information about what's going to happen, then things will change. And I would argue this is one of many, many examples, and I do a lot of work with social psychologists, suggesting that that's just not going to happen. It's really not about new information anymore. So as we have become more certain about the climate science and the effects have become clearer, there's been a small increase in Democratic support for doing something about climate change and a small increase in independents, and Republicans have become less interested. What does that tell you? It is not about the information. Something else is going on here. And that's a lot of the research that I do trying to get to the bottom of that. So here's one example of what is going on. This is the way people remember the weather in the past. And what I would tell you is that climate is all about group identity or partisan identity. And what people do is they adopt a mental model. This is what I believe, and this is what I don't believe. This is what the members of my group believe. And then they engage in motivated reasoning and confirmation bias. They pick and choose the information that's out there to fit with that mental model. They don't change their mental model in most cases. And we must design environmental policy in a way to deal with that, and that's a lot of what ESG is all about. So what does this tell us? This tells us that if most of your friends are Republican, you remember prior winters as being colder than they actually were, because that's consistent with your view that climate change isn't happening. If most of your friends are Democrats, why would you say most friends? Because of social desirability. We actually often don't ask people, who are you or what do you do? We ask, who are your friends? And the power of social norms is that who most of your friends are tells us more about who you are than if you would tell us directly. Right? Because people want to believe and do what their friends do. So even memory about the weather has a partisan polarized component to it. Similarly, if you put a green label on a light bulb, you might think, oh, that will just increase purchases. And the answer is it will among liberals, but it will actually decrease purchases among conservatives, right? Even if it will save money. So social identity or group identity is deeply strong, and it's hard for us to deal with that. It's hard to teach that. It's hard to understand that, but you don't understand the practice of environmental law and what's going on with ESG unless you understand that. look at all the states that are lining up in the litigation that we just heard about and ask, what is the group identity of the dominant political group among those states? And it will divide almost perfectly that way. So what is this book about, and why is ESG, in my view, a piece of private environmental governance, and why should you care about that? Well, ESG to me is just one little example of a much broader movement that has emerged over the last several decades, and it is private environmental governance. So we shift from saying, what can government do, to saying, what can any organization do? And the question here is not the intent of the actors. I don't really care whether when Walmart commits to 1 billion tons of carbon emissions reductions working with the Environmental Defense Fund, whether it actually wants to or not. That's not the goal. The question is it performing the function that we traditionally assign to public governance, reducing negative externalities, managing common resources, trying to achieve equitable distributions of resources. So what we do is we begin from what can government do to what can any private organization do. We then need to change our vocabulary a bit because we talk about laws, policies, and programs in law schools, but many of these are hard to describe. What is the Science-Based Targets Initiative? What is an ESG commitment? Is it a law? Is it a policy? What is it? And what we're working on right now, and I'm hoping to engage more with Professor Hahn at a symposium next fall on, is that much of the driver here, and this is a lot of what gets ignored in a lot of this ESG litigation, is that individuals have a moral boundary of the firm that is broader than the legal boundary of the firm. So we get taught the virtues of limited liability. We get taught a lot in law school about when a company is liable for third-party actors' behavior. But what we don't tend to get taught, and what tends to get left out of this litigation, in my view, is that an economically rational decision will account for both the moral boundary and the legal boundary. So if I'm managing the production of clothing at Nike, and I say, I'm not legally liable for the third-party contractors in Southeast Asia who are using bad labor practices, I just lost a lot of money from my company. Why? Because I failed to account for the fact that most of my customers put my third-party suppliers within the moral boundary of the firm, even if it's not in the legal boundary. So what we're doing is research on what are the precise boundaries, what are the precise contours of that boundary. To get from here to where we need to be more broadly, we no longer can just think of international. Again, think about the mental model you're engaged in. It's international is between nations, right? Much of the pressure to reduce carbon emissions in many nations around the world is the product of supply chain contracting pressure from Walmart and Unilever and other countries. What's international about that? It's a network of global contracts that bypasses the failures of the international system. We often talk about regulation. If you notice, my book is called Private Environmental Governance because governance is a broader phenomenon. We talk about requirements, and I often shift more to motivation. Sometimes what we're talking about here are actually legally enforceable requirements, but sometimes they simply create motivations. You often hear the term voluntary, but you'll see almost none of that in what I talk about because it isn't really voluntary, and I think that's something to really keep in mind as you move forward. It isn't really voluntary when a lender tells its supplier or its borrower, you need to have the following things done. So I think it's a mistake to distinguish between what's voluntary and not in a lot of cases. Much of what I see in the literature advocating for change to try to deal with that climate problem we talked about before assumes away political feasibility. 18% of the US population controls 50 to 52 votes in the US Senate. That 18% lives in states like the one I come from, Tennessee, not in states like New York and California. So if the idea is how do we make transformational change, you've got to consider political feasibility. But that could include private initiatives, so it's not always political. So we use the term in the literature that we produce, initiative feasibility. I also would say that if the question is, are we going to solve the problem? That's, again, a mistaken framing. I don't think very much of what we're talking about here is going to solve the problem, but it can improve them. Okay, so a couple other quick points. Am I good?
Yeah, you're great.
Okay, so I mentioned that even our memory of the weather is dictated in part by political polarization. And so how do we bypass that? Why is the kind of work that Professor Hahn just talked about, why is private environmental governance potentially a way to bypass that? Well, here's an example of a comment from Senator Inhofe. I assumed, like everybody else, way back when everyone was talking about global warming and all that, I assumed that was probably right, and then I found out what it was going to cost, and then I changed my view, right? Similarly, Professor Cahill, who is an evangelical and from Texas, and the chief scientist for the Nature Conservancy, said after speaking to a group of Texas producers in Amarillo, one man said it best, "Everything you've said makes sense, and I'd like to agree with you, but if I agree with you, I'd have to agree with Al Gore." And I could never do that. I could never do that. So is it about information? Is it about processing information? No. Get out of that mindset, right? It is about what your group identity is and how that information squares with your group identity and what political and media elites are telling you about what your group can do, right? And we have lots of research on how to bypass that. One piece of research that's promising about private governance, which we're talking about at today's event, is that our research suggests that learning about private governance can bypass solution aversion. So solution aversion is what's going on here. If I don't like the anticipated solution, I'm going to change my view about whether the problem is serious or not. And research at Duke, I hate to mention Duke as a Carolina grad, so I'm going to do that. Research at Duke initially showed, and then our team's research, Gillis et al., validated this for climate, that when liberals hear about nuclear power being the answer to climate change, they become less worried about climate change. When conservatives hear about government regulation being the answer to climate change, they become less interested and worried about climate change. What we have found is that when people get exposed to the fact that Walmart's committed to 1 billion tons of carbon emissions reductions, it does not depress liberal support and it increases conservative support. So one reason to be doing the kind of things that I think many of the third-party practitioners are doing from today's event is that it helps to bypass solution aversion. So where does this fit in if you took political science? This is abstracted from work that David Barron at Stanford did, and Alan Wiseman, who's the head of our political science department, has pulled this together. And so what we often think of and what we're taught as undergraduates or law students is a system in which unorganized interests and organized interests then influence government, which engages through legislative, executive, and to some extent these days judicial events. That affects firms, and that causes market reactions. You can think about what we're talking about with ESG as one piece of private environmental governance, is that when we get the kind of gridlock that I showed you before, this system doesn't work anymore. So what we're having instead is the interests of unorganized interests and organized interests bypassing that government step altogether and going directly to firms. And at a core level, to me, that's what's different from the 7th grade civics or undergraduate teaching that you might have learned. And it's difficult to conceptualize that way. So why then, as a lawyer, should you care about any of this? Well, there are people who came all the way down to speak to us from major firms, so maybe something is going on here. And again, I see ESG as a small piece of a much bigger thing, and I want to show you about that. So first step, if we're going to get out of just staying in the same mental model, is to say, with public environmental governance, what do we think about? International agencies, the federal government, state governments, and local governments. There are parallels at the private level for all of those. On the private level, we think about global and domestic business firms. We think about NGOs, various different multi-stakeholder organizations. For example, the Marine Stewardship Council is a private organization formed by the World Wildlife Fund and Unilever, which was the largest seller of fresh fish in the world, and it regulates 20% of all the fish caught for human consumption in the world, and was formed after an international process failed. How many of you have ever studied that in a class? Right. That's the old mental model. The new mental model is if you want to understand what's protecting sustainable fish around the world, go study the MSC, the Marine Stewardship Council. What we see then too is private environmental governance includes these other industry associated investors, banks, insurance firms, and what we're talking about in large part, based on Professor Hahn's comments, is just the pushback that's occurring to those. Importantly, there are a set of tools you learn in law school: prescriptive regulation, property rights, financial penalties, financial payments, persuasion. Jim Salzman calls these the 5 Ps in his textbook on these topics. There are lots of different names for them. Those are the principal tools that we use to regulate, and there is a private parallel for every one of those. Right? And so what this textbook does is it lays out for you what that private parallel is, so you're not just using one public tool, which may not work in the modern era, but you have that private tool as well, and we can talk more about this. So importantly, and I expect everybody in the back to be able to read this. I hope you know, yeah, good, I can tell you can. Yes, so that's why I provided the binoculars way back there. So importantly, in addition to there being actors and tools
For every subject matter that you might learn in environmental law in a law school class that's focusing on the public side, there is a private analog. How many of you studied the National Environmental Policy Act, NEPA? I won't call on you, don't worry, you can raise your hand. Yeah, most of you have, right? That is the leading statute adopted on January 1st, 1970, signed into law by President Nixon on national TV, right? It requires disclosure of the environmental implications of major federal actions. There is a parallel at the global level called the Equator Principles, which reads a lot like NEPA. How many of you ever studied the Equator Principles? Right? 80 to 90% of all the money in international project finance is by banks that have committed to the Equator Principles. It requires similar kind of disclosure. So if you're doing an international project using project finance, which many of you will do, you want to know about the Equator Principles. There's a parallel between NEPA and the Equator Principles, and you'll see the same thing is true across multiple different subject matter here. Okay, so why is this happening? And this gets back to some of this pushback we just heard about. We teach in law school that firms have a legal license to operate. We don't call it that in many cases, but that legal license is formed by statutes and regulations, guidance enforcement, and responses to tort law. But literature on organizational behavior, Gunningham, Kagan, and Thornton is one good example, suggests that firms also have a social license to operate. Ask the managers of Bud Light if they failed to think about the social license to operate when they ran into a buzzsaw recently. Ask United when it dragged someone off an airplane to put a pilot on there and then lost $1 billion in market value overnight, right? Thinking about that social license to operate is hugely important, and it goes to a lot of the questions that Professor Hahn talked about, because these have raw economic implications as well. They don't just have moral or woke implications, they affect literally the ability of a firm to operate. So let's think about that for a little bit more, and then I will shut up. Why is that true? Why, if you're a manager, even if you're being sued for, in theory, engaging in woke behavior, why should you nevertheless be thinking about this? This is public support over time for stronger environmental requirements, right? And it is varied over time, but it's maintained somewhere between 60 and 70% much of the time. The Supreme Court just removed half of the protections for wetlands in the United States in the Sackett decision, but 75% of the American population wants to see more regulation of wetlands. So if you're managing a company, the government and the Supreme Court is increasingly getting out of line with what the general public wants. And let's talk about the economic implications of that. So my suggestion is that we can better understand how private governance is occurring if we think about what the drivers are. And they aren't just whether you will buy a green good if you go into Whole Foods or not. It's much more fundamental, much more important, and widespread than that. One answer is accelerating efficiency. I have a piece from Nature Climate Change from this time last year that shows that carbon labeling doesn't really change individual behavior that much, but it induces firms to find efficiencies in their supply chain. And you'll see in the book that Professor Jaffe held up to you, we have one example, which is Walker's Crisps in England. It was bumping along, not worrying about climate. It got pressure from the Carbon Trust to disclose its carbon footprint. When it did that, what did it find? It found that it was buying potatoes by the pound. And what does that incentivize farmers to do? To dig them when they're wet, to store them in humidified warehouses, and to transport heavy potatoes. It found that a dominant force of its carbon footprint was the mechanism by which it was buying potatoes. That would not have been discovered had it not been for the pressure it was under to carbon label its products. Sometimes it's about assuring supply. A statement from one major food executive says, we're big enough we can wipe out whole fisheries if we don't think about how we protect them. That's one of the reasons why major fish retailers have signed on to the Marine Stewardship Council. Brand or reputation, very important, and it's a real thing. Again, if you ignore brand, you're ignoring the economic implications. Are you doing your job as a corporate manager if you fail to ignore that? What does brand or reputation matter for? We think about retail customers, but I would say that they're a second or third tier concern. They do matter a lot, but what matters as much is employee recruitment and retention. Right? I've had people tell me that that is the principal reason why one might do this as a company. Similarly, corporate customers. I've done some research that shows that 80% of the 10 largest firms in 7 global sectors are imposing environmental requirements on their suppliers. So you may not care yourself in your own business, but if you want to do business with X Corp, you need to comply with their supply chain requirements. Obviously, lenders are, all 6 of the major lenders have adopted carbon policies. Many insurers have, and they're all subject to this pressure. And again, if these things didn't matter, would they be getting the pressure that we just saw here from Professor Hahn, right? If these were just window dressing, things that you shouldn't have to study, shouldn't read my book about, why would we be getting all this litigation? Right? Why would we be getting it? Manager norms matter a lot too. You all will go into private practice, and there are times you will be at the table, and the question will be, can we do this bad thing? Right? And you may have the decisional space under the business judgment rule to do it one way or the other. And research shows that if you're the one who stands up and goes, I'm not sure that'll be good for our reputation, you can take an entire group and change its direction because many people were thinking the same thing. But if everyone is shut down, you may not get that. Measuring manager norms is very difficult. I've done some empirical work on that, very hard to do. And of course, today's topic is investors in ESG, and I will wrap up here. Obviously, again, you ignore ESG issues, then you're ignoring maybe a quarter of the retail investing that's going into funds right now. One thing I'd like to talk about too is the common ownership idea and what the current state of the literature is on that. I know there's some people here who probably know more about that than I do. There are lots of different initiatives. I don't want to waste a lot more of our time, and I'm happy to talk about specific initiatives that are underway. When you start studying this area, it's truly remarkable how many of them are here. What I do want to do is wrap up with this, which is a big concern, is greenwashing. So how do we separate those firms that are doing the right thing from those that really aren't? I have an example for you of how you can deploy private environmental governance to deal with the greenwashing problem. This is with Oren Perez, who is a law and econ scholar from Israel. And what we've suggested is two different kinds of forward contracts as a way to hold firms' feet to the fire. So if you're actually concerned about achieving a net zero commitment, let's say you've made it for 2050, the problem all of us might have is we can't tell which of those are genuine commitments and which of those are not. So how do we create a separating equilibrium between those firms that are genuinely going to do this and those that are not? One answer is we offer a carbon letter of credit. So essentially, a company that has made a net zero pledge enters into an agreement with a bank, and that bank issues a letter of credit. And what happens is that the pledging company ultimately agrees that the bank can buy offsets for every ton that the firm misses its climate commitment. So you know when the firm makes that commitment, it is committed not just to reduce its emissions, but to buy a high-quality offset for every ton that it misses those targets. And as a result, we can begin to enable firms to separate those that are actually making good faith commitments from those that are not, and you would use a climate trust or some other NGO as the beneficiary to ensure that this could happen. We could talk more about that. Okay, so as I mentioned, 80% of the firms in 10 global sectors are imposing environmental requirements on their suppliers. And I want to just end, every class I start in environmental law, I start with a slide on optimism. The research on your generation shows you guys are not optimistic. And you can see it given what we've talked about already, right? I get that. But that affects your health. It also demobilizes you. You can't actually do good things if you're really worried about the future and feeling doom. There are lots of reasons not to feel doom. One of them is that the price of solar power has gone down by about 90%, as has wind power. So if we're thinking about, are companies just engaging in woke behavior, or are they choosing the lowest cost of power that actually accounts for what their employees and their shareholders and their customers care about? Decide for yourself. U.S. power generation, this is again a part of the reason why we're seeing all this litigation. Renewable power has now passed the power generated by coal in the United States. And this is my most favorite one. I have a paper called Forks in the Road that shows that if we decarbonize electricity, electrify transportation, and electrify buildings, we can get 70% emissions reductions in the United States. Much of that will occur through private environmental governance. Almost all of that is politically feasible as well. This is Fifth Avenue in New York in Easter in 1900. Anybody see any cars there? They're all horses, right? 13 years later, anybody see a horse? Right? We made that transition in 13 years. Was there a federal mandate for that? No. Now, there wasn't also a polarized society in which there was an active pushback like we're seeing. But we can make rapid transitions, and these kind of transitions are underway, and we have a lot of research right now on EV uptake and polarization uptake. I'd be happy to talk with you later about that as well. So I've included in the slides lots of links to papers, and so I hope you'll ask about them and ask for copies of those papers as well.
Thank you all both. Annie, I know we're pretty much out of time.
We can ask a couple questions.
Okay.
If you want to ask them or the crowd, either way.
Sounds good. So I'll start with one, and maybe the three of us can sit up here, and then we'll take two from the crowd, and then have our break. So my one question while we're coming over here is, I remember, I think it was 2017, we had Avi Garbo, who's another UVA law graduate, here for a conference. He had been at EPA, he had then transitioned to Patagonia, and he said one of the things he really liked about the transition was government was one step forward, one step back. You know, Obama administration does X, Trump administration rolls back X. And he's like, you know, in the private world, like we can keep marching forward consistently. And yet, Sarah, your presentation suggests maybe not so much because there's all this pushback. So my question for both of you is just, was Avi Garbo's instinct in 2017 correct that despite all of the litigation pushback, it is more consistently forward progress on the private environmental government side, or was Avi Garbo wrong on that?
Oh,
Sorry.
I think he's right. I mean, I am not giving up hope that we're going to see a backlash to the backlash. You know, the courts have been resisting to some extent the backlash, and I think there's just enormous momentum behind the private governance solutions, honestly, for a lot of the reasons that you were outlining. I mean, it just sort of makes sense for business. So I'd be curious to hear.
Yeah, no, I share that view. I think that there is essentially a dynamic equilibrium between the public and the various governance structures that are out there. And I think of this as market democracy. I think that a politician can gerrymander a politician's market, that the constitutional design provides for 18% of the population to govern what the government does. But if you are Dick's Sporting Goods, and let me just ask, this is the way I ask this question in class sometimes, who's the largest regulator of assault weapons in the United States? And I've given away the answer, of course, just the way I've got this bad humor, but it's Dick's Sporting Goods. Why does Dick's Sporting Goods not sell assault weapons? It has to sell in neighborhoods all over the country. It can't gerrymander. It can't only sell in my state, Tennessee, where selling assault weapons would be a great thing. Like they would sell a lot of assault weapons in Tennessee, but they wouldn't be able to sell them in San Francisco or New York or elsewhere. So I think there are features of the market system, ironically, and again, I wasn't this way when I first started working in this. I was all in on the pure government side, but as I watch the political dysfunctions that we face, and as I do social psych research on the depth of the political identity issues, you can give 100 Republicans a policy and say, Republicans support this and they'll support it. You can give them the same policy and say Democrats support it and they'll reject it. And the reverse is also true. So I think our political system in this modern world is not reflecting on a regular basis the views of the population, but I think ultimately there's this underlining kind of hydraulic grinding force that occurs, which is you can't get too out of line with the majority views of the population. And I think what we're seeing is that occurring. And I do think that there are times when, because many people working in this space are in a liberal bubble, basically, they fail to understand and think about how we respect and account for the views of people outside of their own bubble. And I think more and more, I've got a book in the works on that phenomenon. The more we do that, the more we understand that people who disagree with us, in very many cases, are well-intentioned, good people, but they have a different view or they've been persuaded that their own group does something different. I think the more we address those problems, the more success we'll have on the governmental level. For now, I don't think of any of the stuff we're talking about as solving the climate problem. I see it as buying time until the climate problem is so obvious that even in our gerrymandered, gridlocked system, that we can still make, that we still have enough time left to solve the problem.
All right, let's, questions. I think we have time for one or two if folks have them. Yeah.
I really liked the chart you showed that showed different countries' carbon output. I think to a lot of people, they don't know that the US has made that much progress. And I also like the idea of transitioning to private action doing so. One question I have though is you illustrate well that so much of the climate problem in 2024 is not a American specific problem alone. And to the extent that private action can make meaningful transition, obviously many American companies are invested in China, but I'm not certain that a totality of China's carbon emissions is from private actors versus China's state action to develop much of China, build railroads, build airports, everything they're doing. Do you think that there's a place where like this private action mechanism can kind of like tip the scale and like make enough of a difference in China's own emissions, or is too much of it grounded in state action and it would have to be threats of removal of like American supply chains from China to change public policy in China, or is it centralized in the locus of private action in China?
Right. So, so one just thought is that some studies suggest that maybe as much as 80% of U.S. carbon emissions come from our supply chains. So when the SEC backs out of requiring reporting on those supply chains, it changes the pressure that companies feel on this. And I didn't file a comment letter, but I did write a paper at the time this was all going on, which basically said that it was private disclosure that was going to drive supply chain pressure anyway. And so I'm not as worried about the SEC backing off as I might otherwise. The vast majority of major companies report to the CDP on their carbon emissions, and they're getting a lot of pressure to report supply chain emissions as well. So I think there is a private level at which, and over time we might see the SEC becoming a little less important than it otherwise is on climate issues. Right now, if you're in private practice, again, people can correct me when they get their chance here, but I would want to know kind of what are the CDP reporting requirements as much as what are the SEC ones. Different enforcement regime, but a lot of pressure there. The other thing I think that's happening just quickly, and it's not quite your question, but I'm worried that we're headed toward economic mitosis. That what we're headed toward is California and New York requiring a business to do X, Y, and Z, and Texas and Florida, W and something else, whatever the next letter is. And so I worry that what we end up with was something that looks like a country, but is actually two economic units that won't deal with each other within that country. And I think one benefit of private governance is that because of the avoiding solution aversion, it can kind of take down the political polarization around the issues that are otherwise dividing the country. As to China, I would say that this is a great example where private governance is not going to solve the China problem. I have a paper called The China Problem, and the China problem is twofold. Part of it is China's emissions. Part of it is the way China's emissions are used in the U.S. to stop the U.S. from doing more, right? Because why would we do that? Because China won't solve this problem. Well, I guess my view is much of the Chinese economy is still driven by exports, less than it was, but much of it is. And to the extent the U.S. and Europe and Japan companies are insisting on lower carbon exports, that will put pressure back through China to make some changes within the Chinese economy. And it won't change how they build railroads or whatever, but all those things that affect the carbon footprint of the products they produce. So it does have some second order effects. An example of that would be Apple was under enormous pressure to reduce its carbon emissions from its iPhones, et cetera. And it found out that many of its Chinese suppliers were using largely coal-fired power. And so that was hard to change on some level. But what it did is combine with some others to fund the building of renewable power plants in China to fuel the manufacturing of its iPhones so that it could sell low-carbon iPhones in Denmark or New York or whatever. So I think we're already seeing not only almost regulatory type pressure through supply chains, but we're also seeing the equivalent of subsidies coming through market systems that are inducing changes in places like China and India.
Sarah, did you want to add anything on China and sort of that issue of, non-democratic government, railroads, coal plants, et cetera, that are sort of outside, it seems, of the purview of this effort?
Well, all the I agree about supply chains. I think that pressure is real. And I think you mentioned another thing that I just wanted to hit, because I didn't talk about it in my presentation, but this idea that the United States could become sort of our law is less important, and that we'll lose our place, that by not leading on some of these issues, or the retrenchment is causing us to sort of fall behind internationally, that then we lose in the business domain, we lose our sort of primacy or our traditional place at the forefront of business governance. So all of these pressures, play out in many ways. But
a way to think about that is, so Texas pulls X billion dollars out of banks. If you're a bank, is Texas the biggest investor in you or the biggest customer of you? How does it compare to all the countries of Europe? None of which will do business with you if you don't do this, right? So what I worry about is like what you say, and this happened to me early in my youth. Again, I'm dating myself, but I watched as the U.S. auto industry insisted on not making more fuel-efficient cars and took itself out of the global markets. There was a time when I think it was GM was the leading seller of motor vehicles in China, right? That just could never happen now, right? Because China is the largest buyer of electric vehicles and manufacturer of inexpensive electric vehicles in the world now. So I worry that in order to satisfy some localized interests, we're disconnecting ourselves economically and getting economic disadvantage, which goes back to the litigation that you're talking about. Because again, it need not be, do you have woke values or not? It's simply, are you accounting for the broader set of economic considerations that should drive the profitability of your sector?
Maybe that's a good place for us to end. The world is not falling apart because of the United States.
If I may, and I know it's taking time, but if I may, I'd like to throw something on the table that maybe some of the subsequent speakers can get to, because there was a movement a couple of years ago to focus on common or universal owners. The idea that very much of the ownership of shares in the United States with the sort of development of modern portfolio theory is held in large diversified funds. And if you're the manager of those funds, and if many of you essentially own the economy, not just any one company. So what is the appropriate response when you're getting pressure to not consider certain things? There was a model that was done that suggested that if the leading investors put a lot of pressure on Exxon and Chevron to decarbonize faster than they otherwise would, the investment fund would lose $6 or $7 billion, but it would avoid harm to the rest of its portfolio of about $9 billion. So what is your obligation if you know that to be true and you own essentially the American economy, not just any one share? I don't know what the current state of play is on that. I'm not in the middle of that, but if I were a student, I would want to learn more about that and get a sense of whether that theory still has some credibility. Has it been blown up? What's the story?
Excellent. Well, thank you, Professor Hahn, Professor Mann.
Anything that you didn't already know.
Yeah, and then I write that's what I specialize in. Yeah, we do great. A lot going on, less attention to the point cause, but I know what you mean.
That's what I'm.
I'm
just curious, I wanna.
Mostly concerned with is the. So state and federal securities disclosures happening.
It's a really fun one. That's true. I'm excited. I hope it's like nice outside, and it'll be nice to do my last year companies here today.
Yeah.
Did you take that?
That's the part.
I like
Oh, yeah, that's a good that's a great idea. Boycotting companies.
You're getting it from all sides.
Yeah. Oh, no problem. Are you sitting up here? Okay. Yeah. I didn't know.
That makes a lot of sense to me. Yeah, because it's natively political, right? I mean, giving legal presentations, talking about the law, but there's just a level at which this is natively about power and gets to.
So like.
Like Green Party, really classic political expression. Yeah.
Right, versus BlackRock.
So, we're about to start the second panel.
Yes, I'd love to.
Hi, everyone. Thank you for coming out. My name is Tony Woods, and I'm the financial editor of the journal here. I'm really excited to see so many excited faces. We're about to start panel 2, ESG and private practice, and I'm going to introduce our speakers as well as our moderator. So first, June Hu coordinates Sullivan and Cromwell's environmental, social, and governance ESG practice and advises on a range of ESG, corporate governance, activism, and takeover defense matters. June has represented clients across the industry spectrum, including in the consumer and retail, insurance and healthcare, technology, and financial service sectors. Representative ESG and corporate governance clients include AB InBev, AIG, Ally Financial, BlackRock, Bank of New York Mellon, Boeing, Butterfield, Canadian Pacific, American Intercontinental Exchange, JP Morgan, Regions, Royal Bank of Canada, Ryder, US Bancorp, and Volkswagen. She is an author of Sullivan and Cromwell's annual proxy season review, now in its 10th year of publication, which identifies key trends in S&P 1500 shareholder proposals and analyzes the implications for issuers and investors. She frequently publishes and presents on ESG and corporate governance matters. June graduated from Columbia Law School in 2015. If we could give a hand for June. And then Steve Nicholsberg, sorry. Steve Nicholsberg is a partner in Clifford Chance's U.S. litigation and dispute resolution practice, focusing on government and internal investigations, complex civil litigation, due diligence, and risk management. Steve advises corporations, multilateral organizations, sovereigns, and individuals with respect to U.S. laws relating to economic sanctions, corruption, unfair competition, and business and human rights and the environment. Steve is a member of Clifford Chance's Global and America's ESG boards and Global Business and Human Rights team. Clifford Chance's Global ESG board brings together a cross-practice, cross-jurisdictional team to collaborate and advise on a wide variety of ESG-related topics, including sustainable finance, the energy transition, carbon markets, implementing net zero strategies and transition plans, complying with the disclosure and due diligence requirements, and managing litigation, disputes, and reputational risks. Steve also is a member of the Board of Visitors of Duke University's Nicholas School of the Environment, a director of the Vance Center Committee of the Cyrus R. Vance Center for International Justice, and a member of the New York City Bar's Business and Human Rights Committee. After graduating Order of the Coif from the University of Virginia School of Law in 1998, where he served as editor-in-chief of the Virginia Law Review, Steve clerked for the Honorable J. Harvey Wilkinson III, Chief Judge of the United States Court of Appeals for the Fourth Circuit, and the Honorable Anthony M. Kennedy of the Supreme Court of the United States. Thank you also to our moderator, Tim Curtis.
Okay, so thank you both for being here today. Both of you are in roles at firms that deal with ESG issues. So I think a great place to start would be to ask, what does ESG look like from a lawyer's point of view? What kind of client questions are coming? What kind of issues do firms need to regularly deal with? And June, maybe we can start with.
So I think this morning for the hour that Professor Hahn and Professor Vandenberg spoke, I felt the lyrics of a song, just echoing the back of my brain, and it's singing my life with their words, just paraphrasing a little bit, because I really thought you were going to let me get away with some of the stuff that I do, but you guys have hit really on all of the highlights in the ESG space.
You actually know what you're doing. We were just sort of talking about it.
Not at all. But, you know, we have been in the trenches living some of the pain of this back and forth, right, on ESG. So, you know, with my firm, we've worked on helping the banks answer subpoenas, helping financial institutions with the states that, you know, blacklisted them because they allegedly boycotted anti-ESG investments, California law disclosures. We've helped companies start to comply with those, as well as trade organizations engaging with California legislature to clarify some of the provisions, of which there are many that are not quite so clear. We, on behalf of various clients, whether they're corporates or they're trade organizations, including BlackRock, on 30-plus comment letters to the SECs. I'm looking at Professor Hahn right now, but neither of our contributions really made a drop in the bucket because there were 24,000 comment letters that the SEC received. You know, antitrust issues, my colleagues and I work with a lot of, you know, especially financial sector clients as they were getting peppered with those antitrust allegations because of their membership in net zero alliances, et cetera. You know, even including recently, you know, attacks relating to their commitment to the Equator Principles, which there we go, I'm taking you through the list. We work with Nike, we work with ABI, the parent company of Bud, on some of their ESG issues if they come up. We even, on a pro bono basis, represent the, and I think we do it with your organization, the Science-Based Targets Initiative as a pro bono client and kind of thinking through their governance. So, you know, really when we see ESG, we see it from the 360-degree angle in the private practice. It's the litigation, it's the regulation, it is what is mandatory, and I think the point about voluntary is such a good one, what is induced behavior and what is mandatory behavior under law, and what is just kind of straddling the cusp at this moment, right? As some of these induced behaviors, some of these pressures that both the professors who spoke before, coming from private sector, translating to, you know, the willingness in, for example, Europe, in you know, Commonwealth countries, and in the U.S. to make legal requirements. We're helping with that type of, you know, governance, compliance, whatever you call it, depending on where on the cusp that transition is in a particular jurisdiction. And we're helping clients who are just, you know, dealing with a massive amount of uncertainty right now, right? In a moment in time where the lawyer's role in ESG has become more important than ever. And I will give one small anecdote and then turn it over to Steve. I mean, my 3-year-old, right? When I tell her, you know, mommy's upset and I need to think about how, like, what we're gonna do to deal with what you've done, that's the moment she goes into her room and starts cleaning up. Her, you know, organizing her toys, she does cleanup time, she sings, you know, clean up, everybody do your share to herself, and gets organized. I mean, this is the moment, and Steve, I'm curious if you're having a similar experience, where a lot of the ESG leadership in companies that has come from, you know, investor relations, comes from marketing, comes from, you know, the people, the customers, and employees, right? People who are your age, who are demanding for something to be done here. A lot of that kind of motivation has gone largely for many years without really much legal overlay, much legal kind of oversight. And so I think we're at a moment in time where, you know, with all the litigation that Professor Hahn described, with all the, you know, other developments that Professor Vandenberg described, we're seeing a moment where maybe, you know, ESG professionals, right, like sustainability folks, maybe that type of hiring, that type of focus is waning a little bit. This is a moment where people are looking to lawyers really for, in many cases, the first time, for answers on how do I navigate, right, this uncertainty right now when I don't know what, you know, the punishment from on top might be if I step a toe out of line.
Okay. Well, thank you, and thanks for the question. Actually, I think that's a nice way to start. It takes us, it jumps us perhaps to some questions we were going to ask at the end, but I think it's a good start because it's a response almost to the question as well. With all this backlash, with the inability of our political leaders to get anything done from a restrictive perspective, with this sort of pendulum and solution is used to go away. And my understanding is, for a lot of the reasons that you it's that a lot of what's driving the underlying work, or whether you call it ESG or something else, is a phenomenon that's different in today's workplace and was when I started practicing. More recently than that, which is that employees demand that they work in a workplace that reflects their values, and customers products that reflect their values, and shareholders are doing the same thing. Now, values are different, we articulate that differently, but I think the directional push in that regard is towards being concerned about the problem, being concerned about what you use supply chain your buying goods, selling goods whether you have a fair workplace and all of those sort of things. So I think that's going to continue to drive. And in the legal world, there is a legal world to that. There's the moral and legal boundary of what firms are concerned about, but there is a legal baseline for that. What's good to do and what's right to do baseline for that, and be able to learn oftentimes so what does that mean for back to the original question of what does the ESG lawyer, what does the ESG practitioner see and do in a firm? And actually, I was going to take that question and say, at least any firm, from my own experience, but I think from common experience, it's a very hard question to answer because it's very hard to say that ESG lawyer or ESG practitioner does. I think, as stated, there's probably no such thing. There are a lot of practitioners in a lot of areas that have topics that are now brought into being under the rubric of ESG in some way, as a part of what they do in advising clients and representing clients. Under E, we have people in transactional practices, regulatory practices, in contentious practices, disputes, like all of them call themselves or describe themselves as ESG people who run funds and who advise clients with fund formation, ESG focused funds, people in the U.S. Outside the U.S., particularly in Europe, there are very restricted, very tentative categorizations of funds that funds spend a lot of time working with advising clients in terms of how to structure the funds and whether the funds can fall by classifications on ESG measures. When sustainable finance, we advise sovereigns on sustainability issues, for example, about development. There's people in traditional finance who advise them on the energy transition, how to get access to some of all those dollars that are out there in the IRA, in funding carbon capture and storage solutions, or hydrogen plants. People who do that sort of practice. There's the traditional regulatory, that's the older school environmental compliance, compliance with clean water regulations, securities disclosures, in place. That sort of compliance for which ESG sustainability regardless of what happens to the people. And those rules just for all of the world, and it's allowed a lot of that. And then you have the litigation disputes folks who are filing things like the schemes as a result of some of the red state theories, but also from the other side, and actually got to the very end before I heard greenwashing. Greenwashing litigation is a significant issue for funds, companies who are responding to a lot of this news and now making a lot of findings perhaps about what they're doing to be sustainable. And we were being challenged in that regard. Either go back on the Sweden statement or an effort by engineers to do law. Because, for example, carbon offsets are a bad idea. So it's to challenge the greenwashing routes. Net zero offsets. That's just environment. Now, also under ESG, we've got business and human rights, which is a huge area, and that involves things like the violence of respect to supply chains. Supply chains is a big one. Bring more effective in the last part of imports from China from regions where the Uyghur population is part of the system. And that's become a very significant risk. Doing business, companies doing business in conflict zones face lawsuits for facilitating litigation. And then DE&I, labor, all of those issues also in ESG. Very different skill sets, very different ways to ESG. So a long response to that question, but I think that it's a great topic.
Great, and I might give you the first crack, Steve, a follow-up here, which is just, I heard about 15 practice areas, all of which are touching on ESG issues. And I'm kind of curious how firms are coordinating across groups, if they are, sort of, what's the firm level strategy for dealing with something that, is a nebulous concept, but it is one that touches so many different practice areas. Is there an attempt to coordinate that, or is this something that's sort of the different practice areas to tackle?
The groups that law firms have strategies. It's an interesting question. I think that the answer depends a lot on the firm and the strength, because these aren't practices that's all just sprung up in the last 2 years. A lot of these practices. Different firms come in ESG with different strengths. Some that are very large and successful environmental practice, for example, or security practice, and that might go after it. I can tell you just from our own experience. Clifford Chance's global law firm, we're across the US, the UK, Europe, APAC, many firms. We didn't start as a firm in the US. Our footprints and the distribution of the jurisdictions. We have lawyers in jurisdictions all over the place that have different elements in the transaction. We've done is create an ESG board. We stood that out 3 years ago. And that's not a formal practice. What that is a mechanism to gather in different jurisdictions, in different practice areas, share information. That's something that people report. But the idea there is to ensure that people try to report that the jurisdictions are familiar with what they do, that are familiar with issues that pop up in a particular area. In particular, the other issue in Europe that affects the international presence has different that they're aware that there's a spot is that they know the person in every jurisdiction, that there's a case incorporate people to the client's ways of operating. And then we have regional boards that bring those regions to the global board, really it's a coordination between.
So how does that look at Sullivan and Cromwell?
At Sullivan and Cromwell, I think we pride ourselves really on kind of having a generalist approach, which is especially important as it goes back to Steve's point about coordination and communication. I think we're at a moment in time where we really cannot practice ESG kind of in a vacuum, right? Like we can't just say, oh, our US disclosure team will do this, and our even within the US, our New York lawyers will do this, and our California lawyers will do that, because and our European lawyers will do something else, because all of these laws that Professor Hahn has highlighted, they are shockingly extraterritorial. They are intentionally and shockingly extraterritorial, and they are intended to do so for some of the reason that the excellent question from the student who asked the question earlier addressed. They're trying to capture something that lies beyond just the entities operating in particular jurisdiction. So I think what it looks like from our perspective at Sullivan Cromwell, I'm probably the closest person to really seeing all of it all at once, all the time. But I work with all our experts who are have been practicing for many years in the areas that Steve identified, right? Our labor lawyers, our environmental regulations teams, our transactional folks who do debt, bond issuances, et cetera, our fund formation folks, and we bring that knowledge together, right, into a small group of us, of which Catherine hopefully will be a member. But we bring that all together kind of in a smaller team that is able to really issue spot in a 360-degree manner. And then once you identify where are the possible issues, traps for the unwary, we then tap in the experts in that broader network to really give our clients the support that in some cases they don't even know that they need because they hadn't considered the interconnections.
So ESG is not only cutting across a bunch of practice areas, but there's different groups of professionals who are sort of engaged in these issues. Accountants have a lot to say. The consultants are always standing ready to advise companies. And kind of curious how that looks from the lawyer's point of view. Is there sort of a natural division of labor? Is there competition among groups of professionals to kind of, actually we're the ones who should be advising you on this type of issue? And has that changed a little bit as the ESG grounds shift?
I think it really, in terms of whether you look at it as an opportunity for collaboration or competition, says more about you than this moment in time, I really think. But I do think this is a period in time where you can, as external advisors, we don't necessarily drive the client's decision making on their ultimate outcome in terms of E, S, or G. But I think all of us are trying to, as external advisors, accountants, lawyers, trying to enrich the process by which that outcome is, decided, right? So I think this is a moment where a lot of us are, like you reach your 30s and suddenly you stop making friends. Well, we're starting to make friends again in the profession. And I think even, an example like the SEC's rulemaking, my thoughts on what the rules implications are have been enormously enriched by talking to, people in the Big Four who are going to do the audit, the assurance providers who are going to look at the greenhouse gas emissions number and say, is the methodology sound or not sound? And so I think Quinn, you're absolutely right. There's a lot of, it feels like there are a lot of different players in the game right now, but it's not really very different to how any new area begins and professionals are trying to figure out what their piece of the pie is. But the really positive thing that I've seen, right, is that these are professionals who care about doing something positive in this space, driving a good process, driving a sound process, supporting our clients through, what I described as the moment my daughter has the uncertainty and starts cleaning her room. Like, I think taking that collaborative attitude at this moment in time, working across a different range of professionals who are all deeply thinking through this space and how to navigate it on behalf of our clients and frankly for ourselves, right? I think that is the kind of attitude that leads to deeper thinking, better relationships, I think the strategy, if you will, in terms of approaching ESG as an outside service provider.
I do, and I'm not sure I actually, if you were open to the answer, what you say really comes to who you are, but I do think there are core competencies in the consulting advisory practices versus the practices. There's a core area in the middle, which is consulting. Where consultants think lawyers are consulting, and lawyers think provide legal advice, and that's where there's a competition. But in the consulting realm, lawyers are not going to be out there nurturing, advocating gas emissions across, or even a small. And that's not our competence. That requires technical, scientific expertise. People don't pay lawyer rates to do it. There's all sorts of reasons why. Consultants, there's armies of people are best. And that's not just being gas emissions, it's sustainability under the European model, which is more than the greenhouse gas. It's sustainability very broadly. Materiality assessments and firm and external stakeholders to determine whether this law to thank them. Just very, very water. That sort of mobilization to the network very lawyers, particularly in a new area like this, are fertile ground for lawyers. That's where the knowledge has a lot of facts. There's a lot of judgment. Analyze the machines that have these things way by relative authorities, and help clients understand strategy, understand risk, that's important. The other secret weapon that we have is the attorney-client privilege, and that's something that we as professionals enjoy that other professionals do not. And this is an area particularly with regulatory change because people who are choices clients that kind of probably do a lot of strategic thinking against the backdrop where they might get sued by a regulator, they might get sued by a NGO. And that's precisely the type of situation where values of the privilege, clients that hold stuff with lawyers about risk, really make a lot of sense. So oftentimes we'll work with a consultant. Their competencies, the data gathering, fact gathering, sub to the lawyer, and the whole discussion talking about actual privilege.
So I'm really curious to hear from both of you about backlash. And when this sort of first came on the radar in 2021 or so, when some states started acting, my reaction was, like $100 trillion in assets of Sun PRI, and I'm not sure that the West Virginia pension fund is going to move the needle. And now as this just sort of keeps rolling, I'm like, well, it seems like they're sure going to try to move the needle, and it sounds like it's really having an impact on how financial institutions have to navigate this space. And so I guess I'm curious on your perspective about how material this impact is, and how the state interventions have sort of shifted over the last couple of years. Is the intensity growing? Is the effectiveness growing? And how's that affecting the ways that clients will engage on ESG?
This is a big question, but an excellent one and a timely one. I'm going to start, there are multiple parts to it. I'm going to start with your point about what's material. What is material to you? And I think here is a really great example of where, you as external counsel, or your organization, your law firm, can help to tee up all of the, the processes around making a decision that the client, based on their strategy, their countervailing concerns, have to make that ultimate decision. So, I'll talk about, I think we talked a lot about climate. I'll talk about diversity, equity, and inclusion for just a moment here. As a person, as a woman of color, I certainly have my views, personal views about diversity, equity, and inclusion. We're in a moment, right, where after the Harvard decision came out, 19 different states proposed anti-DEI laws in the corporate space. And there have been a spate of lawsuits that are just going after companies for diversity, hiring targets, and supplier diversity selection. And so I would be remiss as a lawyer to my clients if I didn't point out to them, here are these risk factors to consider. On the one hand, the Supreme Court's decision doesn't specifically cover private sector. On the other hand, look at what's being proposed right now. Who knows? The language in the one statute is very similar to the language in another. Your risk exposure, if I'm estimating it, would be X. And then ultimately, the client has to make the decision. And it's really interesting when you sit in our seats and see the range of decisions that clients have made on this point alone. Some clients, and you'd be surprised who they are, some of the largest financial institutions have come out and said, we can't back out from this now. From an employee retention perspective, from the fact that we have Canadian and European clients who are actually adopting laws that are meant to catch up with where we were in the US, we just are not going to be able to back out for various financial or legal reasons. We have clients who you may be able to guess who they are. They just say this is so core to our culture and what our clients expect of us. This is our market differentiator, and we really have to stand behind having a workforce that looks as diverse as our customer base. And so that's a reaction too. And then on the other hand, we have clients who are like, wow, we are a heavily regulated entity. We have operations in many of these states, including the ones that have the anti-DEI laws being proposed. We need to roll back some of our, specifically quantitative targets around employee hiring, et cetera. We take a look at our policy to do that. Some of them are saying, let's wait and see, right? We are going to talk about diversity in a slightly different way. We're going to focus on kind of the inclusion belonging arm of it, rather than what our quantitative, diversity commitments are. But we just want to wait. We want to wait to see where the laws are going to land. And so I use that as an example to illustrate that clients have a lot of legitimate reasons outside of the legal, framework that we put together for them to evaluate where they will ultimately land when they're facing, pressures from, and I think we say backlash, but what we really mean is pressure from diverging interests that are increasingly strong, increasingly vocal, increasingly willing to put dollar and force behind, what they're trying to say. And so I think, you know, it's really, if you're someone who likes thinking about the law as a process, the law as a partnership with your clients to make a decision that is well informed so that if you do decide to take on the risk, you do it in an informed way. I think this is a really interesting time to be practicing in an area like this.
Yeah, has there been change? Definitely. But I think a lot of the changes in my life, what clients are just saying where how the clients see some of those who bring the vocal out front are the ones who are on the receiving end of the most of the subpoenas of investment activity, even unfairly under the standards as they're framed. The notion that these large companies are somehow energy providers becomes absurd. But nonetheless, they see what happens if you're a leader. There's a lot of incentive there not to be able to I know I have a lot of this action in this space, a lot of backlash is being focused on asset management, asset managers, partners in that space. If I walk into a client meeting with asset managers and I say ESG today, I'm really throwing out. That's the sense. That's certainly the approach in that space. So there's been a chilling. That what you say, how you say it, depending on the topic as well. But I think that also that doesn't mean that the underlying topics, and Gene was saying with a certain DEI, which is the extraordinary, just made differences in how it's discussed, and tools that are being used, and things like the same thing goes for net zero commitments, for decarbonization, for sustainability. There's really a lot more how it's said. I think perhaps a silver lining is I do think that the effectiveness of just in that space in the environmental sustainability space, there's going to be a lot more rigor, a lot more. You're going to be scrutinized, and you're going to be scrutinized from both directions. Either too woke or too believing, then focuses you back on, well, what do I want to do as an organization? What do I want to do? Strategy. And is what I'm saying is backed by data, backed by policy, and by the challenge. And that's when after a time when you get used to the fashion, and it's just pop out there.
Steve, I'm going to give you this one. We talked about the sort of tension within the U.S. between the two sides of this. But there's Europe out there and the rest of the world, right, that has perspectives on this. It's got to be challenging for global companies to navigate. And I'm wondering in particular, as Sarah pointed out, like we may be looking at a very different ESG landscape depending on how the Fifth Circuit comes down. But I don't think Europe's going to decide that they're not interested in pursuing this. And so what does this look like in global perspective, given the sort of tension to the U.S.?
The world is flabbergasted. I speak with my partners in the same areas, particularly in Europe, where sustainability disclosure is already in place, where the regimes are moving beyond sustainable disclosures to actually requirements for transition plans. There's the notion that there's Jim mentioned some of the non-governmental organizations that were getting attention from the red states because of things like a series of a set of voluntary organizations, the Net Zero Banking Association, the Net Zero Asset Management Association, Mike Bloomberg, and bringing together institutions in those industries to talk about reach that standards and those include institutions and European they were some of the first targets of the ESG backlash on a variety of grounds, including one ground that's got subtraction, which is really very smart because they have competitors really taking steps finance and insure and investing. And the first reaction there was trying to do a good thing. And how we see the company possibly be getting to trying to do that. So within a global organization, we have the kind of pressure and where we're actually and the pressure and the US, how do you manage that? It's not easy. And we do end up with a different discussion and some asset management, for example. We have policy in Europe, we have policy in the States. We're going to separate our products and offerings to reduce risk in and to target certain markets. But of course, for global institutions, it's created a real life. I don't have a nice cat wrapped in go into it. I've been doing it to institutions
No, I mean, I go back to Steve's point earlier, right? Coordinate and communicate, because so much of this landscape right now is not just that there are different requirements in different areas, and you just follow your European entities follow the law in Europe, and your California entities follow the law in California, and your Texas operations follow the law in Texas. They all the laws all come down on you in many cases at the same time. And so it's not even just what the legal requirements are, because a smart young person reading the text of the law and reading some treatises, you could get there too. But what's important about coordinating and communicating is that for every jurisdiction, there's not only the legal requirement, there's also the legal norms that takes enormous amount of depth of experience for you to really understand, right? I think for a lot of European lawyers, European clients out there, you may say, oh, well, the SEC's rules, who knows if they're going to be, upheld or struck down. But what that's ignoring is that we have a robust private litigation, securities litigation bar in the United States, right? Where, the SEC has now laid out 900 pages of what it thinks is material in the climate space for someone to use the roadmap. In Europe, right, I think for a lot of our clients when they were joining Net Zero, they thought, oh, this is for a societal benefit. Of course, it's not an antitrust issue because there's no antitrust harm. And by the way, Europe has a carve out to its antitrust laws that say if you, are promoting public good, you don't have to, there's this limited exception to compliance with antitrust laws. Well, the antitrust regulators in the United States, even under the Obama administration, have gone out multiple times, testifying on the Hill saying, our U.S. antitrust laws have no carve out for ESG, for environmental, social kind of policies. And so, what does that mean? It means if we have, certainly the Obama administration regulators have not. This has not been the first group of people that they've gone after with their prosecutorial discretion. But if we have a different administration, who knows? I don't know, and I'm actually kind of concerned. So understanding the political norm, understanding the legal norm, understanding that broader environment at this moment in time is, I think, key. And having, you know, having a legal team in-house, external, that communicates and coordinates across your multiple jurisdictions where you have operations, I think, you know, to Steve's point earlier, is super, super crucial.
I want to leave a little bit of time for students to ask questions, but before we get to that, you know, I can, as someone who teaches at the law school, that a lot of students are excited about ESG, want to integrate it into their practice in some way. And so I thought it'd be great to hear from both of you, you know, for students who might be interested in this as something that can be part of their careers. Like, what advice do you have for them? Students who think, actually, this sounds really interesting. I'd love to be able to engage on ESG issues. What should they be thinking?
If you're excited, you should be, right? I remember sitting in law school and thinking, oh, I'm just here to learn. Like, I was not a particularly good law student. I met my husband in law school, and he did a lot of my, you know, my case notes and whatever for me. So I was not a particularly good law student, unlike many of you here. I think all of you here. And I just thought, okay, I'm going to learn as much law that's on the books as I can, and I will, you know, learn it enough so I can pass an exam, and I will answer to what the professor is teaching. So I'm looking at a couple of professors, and I'm just shaking my head in shame. But when you're practicing in this area, where laws are emerging, and your clients, right, and in some cases you get to be part of the conversation, you get to have a view of what should, not only what the law is and learning that, but what the law should be. You have a role in shaping the arc of the law, right? And you get to do it as a relatively young lawyer in this space because a lot of the laws are new. So when the SEC rules came out, for example, my team that had, you know, like 4 first years on it, those 4 first years were probably 4 of the, you know, people in the world who knew the SEC's new rules better than almost, you know, everybody else out there. So you get to be the expert because we're all just starting to learn a lot of these new developments. And if you're able to read more carefully, more thoughtfully, think through the issues, willing to communicate and coordinate, right, with the people who are maybe experts in other related areas, you will go really, really far in this area in a really, really short amount of time. And I think that's something exciting. And the bonus on top of all of that is you get to see how your efforts kind of shape what the practice will be in a few years. That's really awesome.
Yeah, and that's great advice. And I'll just second it, just in terms of the opportunity to say this to communities all the time. And one of the things that's kind of most daunting when you get out of law school and trying to find your way, trying to find your place, and trying to and trying to find your path really is that there's a lot of people out there already, and it seems that certainly there's well established practitioners who've been doing whatever it is we're doing it for 12 years and right up to date. It's going to take a very long time. This is a new area. Notwithstanding the fact that the strands of practices over time, the framing change is spectacular. The new regulations are coming out. There's a place for some recognition and establishing expertise that some of us have and become very valuable. And we've seen the exact same thing between us with perspective. We've seen people who are really stepping up and speaking at lunches and fighting thought leadership and putting it out there with their name on it. In terms of how do you find what it is that you want to do, I would suggest, because the area is so broad, think a little bit about what within that ESG speaks to you. You walk into a firm and say, I want to be an ESG lawyer, and given the descriptions that we provide, I think you might see that might not be very much. Because I am really interested in building on finance. About development banks and financing. I'm really into the energy transition, cool, solar, and carbon capture projects. So I'm really regulatory there. I'm thinking that's if I want to an NGO, push this. Finding those passions, those interests, and then there's going to be an element of each of those where there's an ESG, environmental, social. So I encourage thinking about that's kind of.
Thank you. Questions from the students or anyone in the audience?
If no one will ask, so what about the thing I ended my talk asking a little bit about, which is this notion of if you are a common owner, if you manage funds that are index funds, how does that influence the analysis of whether you should or should not engage in some of the ESG related areas? Is that something people think about? Do you have an obligation? What if your firm also, of course, represents some sectoral funds? So your firm has a fund full of oil and gas stocks, but maybe the majority of your firm's management is of diversified funds. How do the various different interests intersect there? What does that suggest about how you should manage that?
I can get us started, although I will cabin what I say with we represent several of the largest funds in the space that you may be thinking about. I will say, to Steve's point earlier, the way people are talking about it has changed. So if you redline, right, BlackRock's 2022 benchmark policy against their 2023 policy, you'll see the word environmental, social deleted and replaced with material, right? And so material risk oversight rather than ESG risk oversight. I think you'll also see this idea of the common ownership structure itself being under attack a little bit, right? The push towards pass-through voting, the push towards giving the voting power, voting decisions back to investors. I mean, BlackRock just recently had pass-through go to its largest retail fund. And so I think there's also some push there, although the immediate response from the other side has been, well, are you fulfilling your fiduciary duty by giving away your stewardship rights here, right? So I'm not sure that there is one set course in which these asset managers are traveling, and I think part of it is we're trying to figure out among this uncertainty what our obligations are. But I do think one thing has crystallized, and it goes back to Steve's point earlier too, which is thinking through what are the areas in terms of a process design should I impose more rigor. And when you go to asset management conferences now, there is the echo across the room of we're talking about risk stewardship. We're talking about a governance framework where our portfolio companies are able to manage that risk no matter where it really goes from an ideological perspective, but there is a framework in place so that we're not just venturing into unprofitable or massively exposing risks blindly.
I have one more question. There's not one that maybe we can end on, and that is, I was curious, as firms, as law firms, right, how has the ESG pressure affected the way firms themselves operate, not just advising clients, but as businesses, right? Are there aspects of disclosure or concerns about social pressure, or we've heard a lot about what employees care about? And I'm just curious how ESG looks to law firms as a business that might get some ESG pressures.
Yes, and we do. We're a business. We're $1 billion business. So like other business, we have 6,000. So we do actually give a lot of thought to making sure that they, as owners of a business, we actually think that we've got a particular obligation and responsibility to we're advising clients every day. We are doing these sorts of things. That they ought to look at these factors and these metrics and be transparent. And so we think it's really important to walk the walk. So we have a responsible business committee. We have the issue more that's external facing clients. We have a responsible business committee that's we publish a report that was public, a sustainability report. It's on our website. And the report goes through all the same things that you would expect to see, especially activity. But because we're a people business, actually, we wish to report it on issues. Hiring and retention, compensation, diversity at all stages, which is the issue. Diversity across gender, across race, LGBTQ issues. That's a major part of our report. We also report on sustainability, largely focused on supply chain, and emissions. Emission reduction. The hard part for law firms is responsible business in the context of compliance rate. And that's a very difficult question. To report consistency to clients that have ESG issues to manage. If you're in the transactional business, and we advise clients on transactions. So there's a lot of discussion in the industry about that. It's highly controversial. Include the responsible business stream with respect to ILI.
I'm gonna have my last remark start with a song too. It's my daughter's favorite line from her favorite Taylor Swift song, and if you remember back to when I said she was a 3-year-old, I apologize. We let her listen to no classical music and only pop music. Apologies, but it's hi, it's me. I'm the problem. It's me. That's the thing that as a law firm, we never want to have attached to our representation of the client, right? So when we are thinking through the engagements we take on, the type of work we do, even what we put out in public literature, we're really trying to think through all of it through a risk mitigation angle for our potential and actual clients as well, right? When we are doing our reporting, which even private companies like us have to do under the California laws, we are really thinking about having to do it in a way that's measured, maybe less inclusive of all the things that we are trying to do but haven't fully fleshed out yet, but doing so in a way where we're never going to be the problem.
Well, thank you so much.
We're gonna take like a 10-minute break, everyone. Okay, perfect, and then I have a gift bag for you.
Oh, you know what? I'm gonna bring I need to go get a phone charger from the library.
No, it's really nice.
I yeah, the good things guy.
I thought she was saying is that it wasn't.
Oh wow, yeah. It's a game changer.
Yeah, that's no, I know, but I don't think they're gonna offer.
Oh, I know you.
Yeah.
It looks so pretty. Falling into its glass.
There's so much going on.
It's just
Amazing.
that's awesome. It's fun. It's kind of a weird beat to me. It was I was kind of like, there you go. We don't got that on our squad. I wasn't like, no, and so, right, yeah. I don't think they want me to be in and then it gets hauled off and the released it, which most of us thinking it sounds. I'm always fine, but I try to never get speaker and I just like, so can't for that class. Sometimes they're like, no, because, you know.
Even if it's some jurisdictions that are great but aren't of this sort.
No, that's right. The like probably not. Yeah, that's right. Yeah.
Yeah, I was gonna say.
Yeah, she's not a fan of that. Still at HE, that would be exciting.
I was gonna say.
I think I would say the other problem is it's like the famous quote, you know.
Well, I hope we get a chance to talk to you. I was telling you, I'm kind of working on a paper.
Being on the journal.
Yeah, I'm looking at the assets.
Yeah, not on the journal.
The bottom line findings.
Yeah.
I had him for second.
Yeah, me too. Yeah, yeah.
This flag and that.
Honestly, if I saw next to her, I wouldn't miss it.
Oh, yeah.
Whenever. Yeah.
Yeah, not expect. I wasn't. They run up into.
Patagonia, that has been exciting.
It's never been popular.
Maybe
It's
from
Ventura,
Ventura,
institutional investors going to be my big green fund or okay, it could be the UAE. And so maybe they're the ones.
No,
Okay, that's good.
I'm from like maybe an hour and a half south of that, and then I went to school.
Maybe that could be it.
Got stuck in the front. I'll make my way back.
Science of law, which is a class we took.
I had that. Oh my god. I was like, come on the run. And I was like, coming on the run.
Like the problems are so
I wish I had anything.
So I think once you have children in a marriage, you need
Just around here.
How are you today? Are you okay? I know I'm
They ended up. I just did 6. Like I just go around the farm. But I think I should focus on when you don't have to get on the trail like above the yeah, like just what goes back behind. I like that. Yeah. I just don't like that you kind of like hit a dead end because to keep going at the point
It's a lot of us like when did all this stuff happen?
or you have to go buy like photos.
No, we don't.
It's good. Yeah,
Yeah, it was cold, it was pouring rain, and I was like in November, I was like, should I do it again? Because I think it would be really fun if it was in nice weather. Then I decided against it, and like, thank God, because it's gonna pour rain again.
I was gonna say it's gonna be the same.
Yeah. It's like, I feel like it'd be so fun in the sun because it's like a really pretty way to like see the Prince of Charlottesville you haven't seen.
I know
like,
too, I was talking to a reporter and I was trying to
obviously like not.
talk them out of it.
Yeah, it was
Me when I asked.
Yeah.
You won your, this is your.
Oh, no.
That's so true. Would you like something in the show?
Oh, no, I wasn't there.
Okay, for sure.
Did you ask her for, are you?
Yeah, I did, because I told you I was gonna do it. I was like,
Yeah, I
trying
remember
to
that,
participate in
yeah.
class. Even though I don't really have. Yeah, no, she was like so nice.
I think she should write.
But I was like, oh, like Bridget's definitely gonna. You were like right there.
No. Where was I?
I see the Austin Cafe, like that.
Oh, is that you talking to her?
Yeah.
Oh, okay, because I was on Zoom. Was this like Wednesday?
Yeah, whenever.
Yeah. I was on Zoom, so I was not listening at all. But I did see her there, and I was like, I couldn't see like who was talking to her because she was facing me. But I was like, oh, like nice.
Yeah, I remember telling you, I was like, I'm gonna participate.
Yeah, at the beginning of the semester. Yeah. I see that. That's why I talk so much, because she makes the little tally like each time, and then it gets in my head, and I'm like, I have to participate like once.
Like she's like.
Oh yeah, I see her. I always think she's just like doodling. She's so
she is like doodling.
Like just like that. Yeah.
Sometimes you're like keep circling.
I do see her doing the circle, but
I think if you participate.
So it's just she's more keeping track of people that haven't as opposed to people that have. I mean, it's a really easy class to just like share your opinion on like one.
I'm just scared of getting like shut down.
Yeah, as a man, it's probably
Everything I said.
Really?
Even though I was like, I'm sorry, I just raised. I don't know how I come down.
Well, I've never thought you said anything.
No, I got
it. Yeah, you're totally fine.
Let's go, Richard. I can do this.
No, stop. That's my first.
West Coast Wanderers.
I said the same thing back in the November.
Did you? That was funnier when I said it. You definitely remember. I did not hear.
That's so much better.
Yeah, it's actually really nice.
Yeah,
Sweet.
Oh my God.
How much do you read? You probably left a better impression. Great impression. A great one, guy. Get your mind out of the gutter. A great one. A great one.
That's the only thing I don't.
Trademark? Yeah. VLBR trademark. As a trademark law. This is a cool trademark too. And you be a trademark.
I know. It's like a weird endorphin.
Yeah, this is I did the J2 version. I did this. I feel like it's so fun.
This is.
I didn't forget that.
And they can't say that.
No, they can't, right? You can't do that. Did it like specifically make fun of? No,
Yeah, I was like, this isn't targeted.
It's like I feel like all I got to do is get picked up. Actually, pricing. First of all,
Yeah. They have your names. They don't have mine.
Like, all of your. Oh my God, yeah.
No, I thought it was cute to do that. They don't do that for us in Wheeling. I did get a $45
Hi everyone, we're going to start in about 3 minutes, so if you haven't got your food, please get your food and sit down.
I got trouble. I got trouble. I'm on. What's in that? Organizing a dinner. I was like, what's the have your number?
Yeah.
Not Hibachi. Well, what is it? We're going Hibachi tonight. Really bad.
Well, now it's Friday.
This thing is like not.
PR day. We're going to barriers and like
It's really sad to say that I was in a same class
I'll pay the people
It's more like how excited I am in my it's like I'd rather have like
I turned my.
How excited am I?
try to do the right thing.
No, just take the page out.
Alright, there's still
Raj, are you gonna?
That's a nice jacket.
I saw the watch this
Well, so Matt and I are making this live.
Yeah, we can get it. I think. Don't put it in your jacket, though. You might have a little bit.
Yeah, I know, that's.
I'll be wearing a lot.
I should have paid the $12
I paid dude. I know.
There's like a level to that.
Alright, bye.
Well, it's nice that they, it's not that they wouldn't remember you, it's just like they're friendly.
I just had a very
Yeah.
I feel like that I have
Plus they have packing my clothes.
Probably got everything else.
I see a lot of people going.
Dave's here and everyone else is
That's actually North Korea. It is, that's a vibe. I was the first person to say. Love those guys.
Oh, got it.
We have the address.
Then we can
Hi everyone, thank you so much for being here. Sorry about that. Hi everyone, thank you so much for being here. My name is Abaya Chakrabarti and I am the Assistant Special Projects Editor of the Virginia Law and Business Review. I'm so excited to introduce our keynote speaker. Hillary D'Souky has based her career on the conviction that leading with purpose and values will create positive change for people and the planet. She joined Patagonia in 2012 because she felt it was the best example of a company living its purpose. We're in business to save our home planet. In her decade with Patagonia, Hillary helped shape Patagonia's approach to corporate governance through its benefit corporation status, which is based on a commitment to evaluating social and environmental considerations alongside financial return. In 2022, when Patagonia's founder, Yvon Chouinard, decided to take that commitment even further, Hillary helped take Patagonia purpose, designing and executing the transfer of all of Patagonia's stock to an environmental nonprofit and a purpose trust, making Patagonia the first purpose-owned company with Earth as its only shareholder. Before joining Patagonia, Hillary was chief counsel for the Levi's brand at Levi's Strauss & Co. during a period of increased social and environmental consciousness for the brand. Hillary graduated from the University of Virginia School of Law in 1997 and the College of Arts and Sciences in 1993. She lives in Santa Barbara, California, with her husband Alex and high school daughters Lyle and Sasha. We also want to thank Professor Barzuza for moderating the panel. Please join me in welcoming them.
We're going to start out by playing a quick video.
Never wanted to be a businessman.
Can you guys hear that okay? Okay.
I never ever wanted to be a businessman. Over the years, it just kind of snuck up on me. We didn't want any part to do with mainstream society or counterculture. Climbing was something that nobody understood. I want to be in the mountains. I was worried that we would become a bureaucratic behemoth. And we would become part of the problem.
Once you realize your limitations, change it.
When I started living in Peacock at 18 years of age, the wetsuit had not been invented. My spearfins and shirts in the winter months wearing only a wool sweater. We were the first company to apply the principles of industrial design and designing clothes. Nothing is perfect, not when there's nothing left to add, or there's nothing left to take away. We were the first to commit to 100% organic cotton. We use hemp and to make fiber from recycled soda pop. We invented the concept of layering for cold weather. Our warmer program started the fashion of buying used clothes. We were the first in our industry to work with fair trade factories, and we taught the world how to create a world-class corporate child care center. We started the 1% for the Planet organization, which now has given away $360 million to nonprofit environmental organizations. Those 1% of its sales to environmental projects. Thank you, Mr. President. Because of our pioneer work, we have become one of the most respected companies in the world. And now, by turning over the ownership of the corporation to our home planet, we are now reinventing capitalism.
What we're after is freedom that comes with peace and potential. I think this is
literally the Earth is the only shareholder of the company. I think it certainly is about fluidity and kind of continuing all the good that has been done by this company.
And looking back, yeah, we have worked hard. We want to be the best company in the world. But let's say we had it pretty easy. when you play your own game, you always win. We had a great time breaking the rules of business and making that work.
I want everybody to understand that everything that everybody does is actually building what the company is going to be like tomorrow.
The real secret of our success for the last 50 years has been our unrelenting focus on quality. Unfortunately, the next 50 years won't go so easily. We all face the dark specter of global climate change and the chaos that will cross the world economics. This said by somebody wise, it's not the strongest species that survive, nor the most intelligent, but the ones most responsive to change.
It strikes me as amazing. 50 years after I got here, the best qualities that the company had persist today. You can run a business without losing your soul.
We cannot stand still while doing business in ways that worked for us in the past. But our biggest challenge will be managing growth. We have to go away from thinking that all growth is good. It seems to me that there is an answer in lies in these words: restraint, quality, and simplicity. I didn't know of any billion-dollar companies that I looked up to. I guess maybe we're going to have to start one.
Just thought that would give you a little sense of. Y'all can hear me. Just wanted to kind of give you a little, that's literally a film that the team has made to train our retail staff. So it gets kind of deep into really what kind of the whole picture of life at Packard is like. Place to start us off.
Wonderful. So wonderful to have you, Hillary. And I also want to thank the Virginia Law Business for organizing this superb conference for Ami and the team. I have to say, I dived into the materials of Patagonia, and I was impressed and surprised to learn several things. How far back you go with ESG and the environment, long before this has become a popular issue. How creative you are in creating corporate governance structures and methods in order to achieve this goal of purpose, and we'll talk about that soon. And how significant this commitment is from the founders, who actually are not really deriving any money from the company profits, even though they are the owners. So I think you guys are definitely an outlier in the ESG sphere, and I find it fascinating. I'll say that one of the things that kind of for me was interesting and surprising is that in my work with Professor Quinn Curtis, we looked at the rise in social demand and how it affected firms to produce ESG, and part of it was by customers, by consumers, and then I saw that Patagonia founder Laura Chenard say, we actually don't listen to our consumers because we are far ahead of the curve. So we do more than the usual consumer demand. And I thought, that was both very sincere, but also, again, very interesting and impressive. So if you will, I'd love you to talk a little bit more about the corporate governance, because this is also a lot of your work. The unique corporate governance that you have created over the years, and especially during the last 2 years, creating a trust. And how did you get there? Why did you make these choices? And in comparison to having a non-profit organization, it's like, for example, OpenAI did, and also enterprise of course going public. And whether you think that any of this would have been possible in a publicly traded company.
Great, thank you. I think it kind of started with the company's values and the purpose that really was there from the very beginning. Yvon Chouinard was a climber, and he made pitons for climbing and was recognizing that that was really degrading the face of the rocks that he was climbing every day. So he came up with a better solution that was more environmentally friendly, and then it just kind of goes on from there. So a commitment to the environment was part of the company's ethos from the very beginning. And so in that sense, it was part of the governance structure as well, because it was just inherently part of the decision making. And I think when I think about governance, I think about decision making frameworks, and it's been really interesting to see how Patagonia's has become just a little bit more formalized and structured over the years. It started with kind of the next big step was in 2012, Patagonia became the first benefit corporation in the state of California. Are you all familiar with benefit corporations? Okay, cool. And they really did that as part of succession planning to lock in the values of the company for the next 100 years and past the inevitable deaths of the founder and his wife Melinda, who's very, very involved and close to the company. But that was my first day on the job at Patagonia, was at a board meeting where they were adopting the benefit corporation, the articles of incorporation with the benefit corp commitments, and a requirement that you had to have a unanimous shareholder vote to change them. It's like, well, there were only 4 shareholders, it's the 4 family members, but still a unanimous vote for anything in corporate law is kind of outrageous. So I said, well, can I actually just read over the articles and make sure I understand? And Melinda Chouinard said, well, you can have until tomorrow because we could be hit by a bus tonight, and then none of this would be protected. So they were very committed to protecting the values of the company in the strongest way possible. That then led to kind of a decade of, well, what comes next? The company had grown to be over $1 billion. The 4 family members were the sole shareholders. They weren't interested in really honestly making money for themselves out of the company, but they wanted to preserve the value, and they wanted to release as much as possible now to fight the climate crisis. So they had this huge asset tied up in the company's stock, and were doing tons of good when it came to the environment and through the company itself. But Yvon Chouinard became really committed, and he's exactly as he appears in that video. Super straightforward, totally determined. Like maybe 3.5, 4 years ago, he just said, it's time, we need to come up with something to do with the company stock. And that means selling it so we can give all of the money away or use it to fight the climate crisis, then let's just do that. But there are 4 family members, and not everybody agreed, and nobody really took him seriously. He kind of then had to call up our chairman of the board and say, I'm actually serious. If you don't start working on this, I'm just going to pick up the Forbes billionaire list and start calling people and see who wants to buy Patagonia. So we kicked off a process of looking into structures that would be kind of a different path than the traditional IPO or sale or some sort of a minority investment. And the family was really clear about their goals, which really, there was a very long list, but we kind of went through a process of not everything's possible. What are the things that are the most important? And ended up with releasing as much value today to fight the climate crisis as possible, protect and steward the company and its purpose, and also, this doesn't sound real, but the third one is nobody's a billionaire. We don't want anybody in the family to become wealthy off of this. So there were not very many places to go with that. And we started exploring the foundation-owned models out of Europe. They're much more prevalent. Denmark is the origin of a lot of these foundational models. Novo Nordisk and a bunch of other companies over there have that. But here, if you were to transfer all the stock of a company that wasn't liquid, you have to start selling it off within essentially 5 years, and you have to distribute 5% per year. So it was ultimately going to lead to a sale if we were to donate the stock to a nonprofit. And we discovered this perpetual purpose trust, which we can talk about a little bit more. I don't know how familiar people are with that corporate form, and determined that with a 501c4 instead of a 501c3, you don't actually have to sell the assets. You can hold them over time for as long as you want. And so that was the model that we put into place.
Wonderful. So let me just clarify. So the company really gave almost 100% of the voting rights, or 100% of the voting rights to the trust that promote the environment, and 98% of the ownership of the cash flow to the same trust.
A different entity that's more of a nonprofit. The trust really only has one purpose, which is to protect the company's purpose. So it doesn't actually distribute cash that comes in for philanthropic purposes. But it owns 2% of the stock in total, so all of the voting stock. And then 98% of the stock, the common stock, is owned by the nonprofit.
And then since 2022. And how is it working so far?
Great. Then the nonprofit's funded through dividends that the company issues when we can afford to do so. And so we funded the entities with $100 million in dividends in the first year. And the corporate lawyer on my team who helped with the transaction then went over to run the nonprofit. It's called the Holdfast Collective. It's a collection of it's a group of five 501c4s. But anyway, they've given away, I think, 70 million of the 100 million, and that's one of the objectives, is to really kind of get the cash out the door to organizations, and 501c4s kind of can do a lot more too. It's a little bit more permissive than just grant making, but that are focused on solutions to the ecological crisis.
Do you find that there are any differences now in what the company is doing, or how the money is being used as a result?
No, not really, because this was always so much a part of what the company did. But what's kind of interesting is that we never really talked about financial performance, because we didn't have earnings that we were, earnings targets we were trying to achieve. We weren't going towards some sort of valuation so we could have a kind of some sort of an event. So the real change has been getting kind of our employees to understand that this doesn't mean that we're a nonprofit. We're still a business. We're still a for-profit business. We need to be a responsible business financially so we can stay in business and generate profit and fund the new entities, the new shareholders to give it away. So the biggest change has been kind of getting our internal team we have 3,500 employees around the world, just to kind of understand how this works. It's a little bit complicated, and also what their role is in now being part of putting even more to work towards the company's purpose.
So I wanted to ask, how do you see the content of the fiduciary duties of the management of the company? And because I saw, for example, that one of your messages is, don't buy too much, right? Yeah. And I thought that was really courageous. So how do you describe the fiduciary duties of the management of this company now?
Complicated.
Yeah.
Because there's not one objective to increase the financial returns for shareholders. We kind of, the multi-stakeholder model is truly kind of how we make all of our decisions, thinking about the impact on the environment, on our employees, on the community, and the financial impact as well. So there are a lot of inherent tensions that come up with every single decision that we make. And when I first started at Patagonia, and I came from Levi's, which was a really values-oriented company too. The company's purpose statement now is we're in business to save our home planet. And when I got to Patagonia, I was like, this can't really be what you hear about, read about, and it was just like so much more extreme than I thought. Sometimes the decision-making almost seemed illogical. And then it was very different too, as an attorney and as a legal advisor, to really kind of change my mindset, because we're used to, there's one way to do things and everything comes from a template, and it's all driven by kind of very straightforward risk management analyses. At least it was when I was a corporate lawyer in private practice. I'm sure it's changed a lot since then, but so we really had to learn how to do things differently. I put this quote up on the screen because this kind of gives you a sense of what it was like to walk in the door at Patagonia. Ivan, this is the first sentence of his book, Let My People Go Surfing. I don't know if you've read it. It's really interesting and slightly dated, but he starts it off, I've been a businessman for almost 60 years. It was as difficult for me to say those words as it was for someone to admit to being an alcoholic or a lawyer. It's like, wow, this is going to be really great. But I think that what really came through in that was the perception that he had of lawyers are always going to tell you no, or they're going to look at things with just the financial value at the center, and that's not at all the way we have to make decisions. And it's been just an incredible learning experience and great opportunity for really just completely changing my frame of reference in terms of what's important and what the drivers in any kind of corporation should be.
So is the reason why you didn't go public despite your enormous value is because you believe that, or the founders believe that they would not be able to pursue the goals the same way if they go public?
Yeah, exactly. We were we looked at, and we were really deep into different models, and including, there are a couple of benefit corporations that are publicly traded now, but not too many. And there was something really appealing about being the first, multi-billion-dollar benefit corporation, publicly traded, that was so well known that we could really do things differently. We talked about, like, instead of doing earnings calls, we can actually have, I don't know what we call it, some sort of catchy phrase, calls where we actually really get into like the impact of all the decisions that we're making on, all the different stakeholders. And that was very exciting to the lawyers, but not exciting to the family, who are also very private, and more than anything just didn't want to be beholden to the public markets, and we're willing to kind of take the risk of being able to prove that we could change them.
So being a company driven by value with a focus on the environment probably also affects other areas of ESG and, in general, employees' welfare and so forth. So maybe if you could talk a little bit about that in your company, if you guys promote other areas and how.
Yeah, we do. I mean, we kind of always put our employees first, I'd say. And Yvon Chouinard is sort of the hardcore environmentalist. That comes first before everything. Melinda Chouinard, who's his wife, is the kind of people people first person. And it really comes, there's a tone at the top, we all know, and it's so real and vivid at Patagonia. But we actually pay a living wage to all of our employees in the United States as a starting rate in our retail stores as well. Whether we can, this is an example of the kind of really challenging decision making, whether we can sustain that is another question. It went up 28% nationally this year on average. So there's a constant kind of evaluation of, can we do that? Is it predictable enough? It changes every year. But that was a commitment we made, and we've gotten people to a really good baseline there. We have incredible benefits. We pay our healthcare premiums for all of our employees. We have on-site childcare. We have kind of a whole suite of services for our employees, and we've been doing a lot to try to catch up on the equity, inclusion, and belonging front, because if I'm honest, like the company was founded by, someone, a white man from California who hired his friends, and they hired their friends, and they hired their kids, and so there were just many years of this sort of a little bit too inwardly focused perspective, I think. So we've just done a ton to change that through recruiting policies and affinity groups and premium pay for bilingual employees and just a bunch of different areas there. So there's a focus on lots of different social issues, the environment, and then our impact on the community that we operate into around the world, the communities, I should say.
Wonderful. So before we open it to question, I also would like to ask you more sort of personal question about your work, because I think what you did is really admirable and very creative and innovative. And it's my impression that, these positions, being a CEO or general counsel or chief financial officers, they are so important and so challenging, and at the same time could sometimes feel a bit lonely because you are the main decision maker. And CEOs actually say it a lot. That one of the challenges in the work is that they do feel lonely at the end of the day. Doing something so innovative by yourself that you don't have like other examples, you have to make these decisions. How did it feel, and what did you do kind of to help yourself in this process?
That's a really good question, and the answer really is that it didn't feel that way because we had such a strong core team, and our board and the family, our family, we were meeting. It was during COVID. We were meeting virtually every other week. It just felt very connected. So we felt connected to one another, and one of the values that Patagonia, one of our core values, is not being bound by convention. It's very much of a kind of a risk-oriented company, being comfortable taking risks and making mistakes and learning from failure. So in that sense, it's not as isolating to be in this role and in the decision-making. So that's, I think, just one of the really special aspects of our culture that is something to look for in any kind of company or employer that you all get to go out into the world and
takes a village.
Yeah, it really does.
Yes, great. So let's end by maybe if there's any advice that you would like to give to the students, like, having this really interesting and successful path after being a UK graduate, and then we'll open the questions.
You all are probably doing this already so much more than I was and my colleagues or classmates in 1997, but just really being clear about what your own values are and where you can connect those to your work. That's been something that I've been able to do whether it was consciously or not, I don't know that it was at the beginning of my career, but throughout the course of my career. And on one hand, it's just really fulfilling and satisfying. On the other, there's like a lot of responsibility that comes along with working for a company that has such a bold purpose, and you can never really kind of set things aside. That's the flip side of being connected to a kind of an organization that you feel so kind of aligned with. But I think all in all, it's worthwhile sharing that. I'm sure you have incredible values that you can go and benefit any company with. Hopefully, if they align, then you can do so much more together.
Wonderful. So let's open it up to questions.
So Patagonia very famously, like some number of years ago, essentially stopped making branded vests for like tech companies, law firms, banks, stuff like that. Were you part of that decision, and could you talk about what led to that?
Yes, I was not, because that decision literally came from, we have a kind of a corporate sales division where you take the vest and somebody buys a bunch of them on Facebook or whatever and puts their logo on the other side, which I always hated. I thought it was just super cheesy. I don't think our founders really liked it, and neither did the person who was taking an order at the corporate desk one day, who basically just said, "Oh no, we're not going to sell to the financial industry anymore, anybody who's not a B Corp or a nonprofit." So then it picked up a ton of press, and it was kind of around the same time that, if you all watch Silicon Valley, the kind of hilarious Mike Judge show, where the one guy who's one of the characters would always wear a Patagonia vest, and Fletcher Chenard, who works at Patagonia, just hated that. So he was like, what can we do to keep it our vest? Fast forward to, I got a call from somebody like a year ago who said, I'm the agent from some agency for Mike Judge. He's going to do another show, and he wants to feature a character in it who is the general counsel for Patagonia. And he's kind of a boob. Are you okay with us doing this? I was like, I don't really see how I can say yes to that. I'm not doing it, but how do you not? So anyway, that show may come out someday with the general counsel of Patagonia. Not after me. So anyway, that kind of thing happens all the time. We just like people within the company who have great ideas and bring them forward. We gave away, I think it was right after the election in 2016 when we felt like we needed to do something really bold. And someone in the kind of the web team said, let's just give away on Black Friday. There's always a big promotion in retail on Black Friday. Let's just give away all of our revenue that day. So we did. We gave away $20 million. It was either 10 or 20 that were from our sales that day throughout the company. That was just somebody's suggestion. So to the point about decision making, and it's a very non-egalitarian company, and really, while we have kind of structure, everybody treats everyone the same. Largely, there's not kind of someone has more power and authority, and of course that exists, but so it's really good in that sense.
Josh?
Thank you so much for being here. I wanted to ask, it seems like the public benefit corporation model in California you found to be very limiting. If you were holding the pen on how to rewrite that law, how would you change it?
We had a lot of conversations about this with, we work with Susan McCormick a lot, who's a corporate lawyer at MoFo, and she was kind of instrumental in drafting some of the statutes. And she's not a fan of the California statute, partly because there's not a clear hierarchy of how you evaluate the different factors that are included in the statute for consideration. So the concern would be, if the board makes a decision that is challenged, and then it's just they didn't have clear enough guidance. So I would maybe clarify that, but the main thing I would do, because it drives me crazy, is that we have to do a report every year. This is silly, but it's just kind of a good example of very poorly worded statute. And you have to, the board reviews it and the board has to include some sort of statement of like, this did not contribute to the benefit that it was supposed to. I would just make it more like real and straightforward, probably.
Gabriel? Yes.
Okay. When you're doing your stakeholder analysis, how do you go about determining who is and is not included in that in your decision-making process? Are there principles, or like where do you draw that line?
Are you thinking who's included in terms of the impact, or who's included in making the decisions?
Who's included in terms of the impact? Like, who are the stakeholders that you decide? Like, how do you decide who is and is not a stakeholder in that decision?
Yeah. Well, within the benefit corp statute, and we're a certified B Corp too in California, and so the kind of the main stakeholders identified through that structure are employees, the environment, the communities in which you operate, including for us in the communities where our products are made largely overseas, lots of workers who we don't have a direct influence over, so we can't directly control their experience, but we try to improve it in ways that we can, and then just governance. So really those are the stakeholders. For Patagonia, the kind of the environment often comes first. It's the company's purpose. So really kind of the employee impact and the environmental impact are right up front. But we also, at the core of the company is quality products, technical products for use in outdoors, which can often conflict with kind of more environmentally friendly materials. So there's a lot of kind of like along the way, even in the product life cycle, making decisions about trade-offs there, but it's really environment, employees, community.
So you sometimes hear academics talk about corporate governance saying that it can be problematic to have a stakeholder model because there's not one thing you're supposed to be optimizing. And I've always been a little skeptical because I think it's probably pretty hard to maximize profits too, right? If that were easy, it would be easy to run companies. So having been on kind of both sides of Levi's and Patagonia, is the intuition that the clarity provided by having sort of a simple profit maximization motive makes decision-making easier? Is that hold up, or do you think that actually it's hard in both places?
I do think it's easier. Whether it leads to better results, I think it is. I don't think it does. So I think part of the beauty of the multi-stakeholder model is that it is challenging and it requires more a kind of deeper evaluation, more conversations, more more time spent on really what are the inherent impacts of any kind of key decision. But it is a lot harder. I mean, there are so many, everything has a tension. There's not, you can't have a multi-stakeholder model and almost ever have a key decision that advances all of the stakeholders' interests. So there's a lot of trade-offs that we're kind of making along the way that I think are also challenging, but also really challenging in a good way too.
Yes.
My question is about kind of like this Patagonia Scope 3 emissions, and like so many companies, I know it's the hardest to decarbonize and something that so many are struggling with. I know that Patagonia has made some commitments around that, but it's not 100% decarbonized. It's a much more reasoned approach, which I think makes sense. But I'm kind of curious about how that goes into the decision-making process in terms of contracting, and with you have a global supply chain, like how you're working with people across the globe to decarbonize. And then secondly, if that impacts the way you think about the redistribution of the dividend process in terms of if it goes back towards retail or manufacturing decarbonization as a whole, like is there a targeted emphasis to decarbonize or reduce climate impact on the exact kind of products that you're creating that have a huge carbon impact?
And that's such a good question. And literally that was the topic of one, half of a day of our most recent board meeting. That's exactly the kind of conversation that we're having. I wish my colleague Matt Dwyer were here because he's got an amazing plan that I probably won't do justice, but kind of in short, we're piloting a program with one of our suppliers in Taiwan to eliminate fossil fuels in their factory. And then we have a great corporate lawyer on my team who's helping put together a contract where it will be more of like a true offset where we'll be able to measure the reduction in that one facility. And we're not the only brand in that facility, but we're actually investing in the infrastructure that they need to transition. And then we're planning to take that and actually offer to sell kind of shares in whatever the offset is to other retailers, and we'll see how that goes. And if that works, we're going to scale that. It's one of our top, we have 5 core key strategies for this next year, and decarbonizing the supply chain is one of them. That will be a longer-term strategy. But it's interesting that you mentioned the dividend because the same board meeting, and this is the kind of conversation that we're having. Ivan Schneider was very clear. He said, if we can actually keep the money in the company and invest it in this kind of a decarbonization effort and really affect change, we want to do that at every time over actually distributing cash as a dividend. So it's all part of the decision-making process. And hopefully you'll see and hear more about that if it works.
Ryan?
One thing I'm curious about, since the structure has shifted to ownership by the charitable trust, how do you deal with conflicts between the charitable trust goals and Patagonia's goals when it comes to balancing stakeholder interests, especially because, if I remember correctly, the charitable trust has more of an environmental focus, while Patagonia may have more of an interest in protecting its employee shareholders or community-based shareholders or stakeholders?
That's also a really good question and kind of a work in progress, really. I like to think about the charitable owner as, really independent. Obviously it doesn't control Patagonia actually because the Purpose Trust controls Patagonia. And that's what's really unique about this governance model, which is the financial benefit is totally separated from control. So the entity that controls at the highest level what Patagonia does, determines who's on the board and all of that, doesn't have any financial interest. In fact, the dividends that are issued to that entity is just 2% of any dividend they can only hold to actually use if they ever have to in order to protect the company's purpose. How that would work could be another really interesting conversation, and we're thinking ahead to that in the future. But so in one sense, that takes a little bit of the conflict away because the Purpose Trust is aligned, the controlling shareholder, with the company's purpose completely. So that, it ultimately has the final control. And the reality is the nonprofit is pretty well aligned with Patagonia as well. And even though we evaluate kind of the impact on all stakeholders, like I said, the environment's kind of always been front and center. So in a way, it's kind of just a nice structure where the environment is just a little bit more front and center because now it also gets the advantage of distribution of profits that it can use. So it's pretty well aligned, and it's all, ultimately essentially controlled by the family members still have roles on the board level of each of these. So in that sense, there's alignment. At some point in the future, that will change. And so we're trying to figure out, doing a ton of research with a lot of these different kind of companies, especially in Europe, where kind of steward governance is much more established, how we want to structure the kind of the stewardship of each of these entities into the future. I don't know if that answered your question quite, but.
Yes?
Given that you've had the experience of using such a beneficial structure,
do you have any advice or any low-hanging fruit for more traditional corporations who still have to follow a for-profit goal? Give me easy ways they can make a positive impact without implicating, shareholder duties and so forth.
Well, I mean, probably Yvonne Chouinard would say that even when you do the right thing, when it comes to the other stakeholders, you're in turn maximizing the financial returns. So that could be one way to think about it. I think that Patagonia is really kind of pouring that out. So I guess really too simple. My advice is too simple would be just do the right thing, and it's going to actually lead to kind of the right outcome, even on kind of in a traditional model. That's one way to start thinking about it.
More questions? We now have a recent studies that suggest that maybe there is a decline in our young generation's preference for values. Still, it's higher than the previous generations, but it went down somewhat, at least in surveys. And do you have any thoughts about that? Why would that be? And again, what would you advise young people in that regard?
I blame it on TikTok. That's really interesting. I hadn't read that. I think we're in a little bit of an ecosystem that where that might not be as apparent. Everybody's so kind of connected about my kids. They're 14 and 16, and my daughter, when she was 8, could define what a benefit corporation was. I mean, it was just weird. They hear about it, so I don't know why that is, but if it is the case, let's change that as fast as we possibly can. Man, I don't know what we need to do to get out ahead of that, but you all are a great place to start, because I can't imagine that that's the way you feel in this room.
I think maybe the students can respond on that. My impression is that maybe it reflects, some fatigue and maybe some frustrations with the results, so it's basically a survey from Stanford Business School, where they find that how much people are willing to give up in salary and to pay more for products. It has just this gap, as the willingness to pay has declined for values. But and that's related to another question, which is how do you control or ensure that the money that is invested for the environment will be invested in useful ways? That's another challenge.
That is, I mean, and I think that's a challenge with big philanthropy, and was one of the things that the founders in this structure were really wanting to break through. And so again, kind of not being, just being willing to take risks a little bit more and move quickly and test and learn. We're just in the first year of this, so we'll see how it goes. We're trying to be as transparent as possible, so our employees and the rest of the world can hold us accountable too about what's happening within Patagonia, what's happening in the nonprofit. We haven't issued this publicly, but we issued internally kind of our first quarterly report that shares with our employees what we're doing as a business. And our CEO, who's just another great example of the right tone at the top. He's an amazing person, and he evaluates every decision through kind of multi-stakeholder lens. But it's true, the biggest impact we can have is through Patagonia as a company, not necessarily through what we're doing through our corporate structure. I like to think that it's through the corporate structure, because that's so my world, and it's really interesting and fun, but we just need to kind of keep doing what we're doing as a company too, and really the people who hold us most accountable there are our employees.
More questions?
Yes. Hi, I was wondering if you could give some advice on the idea of holding true to your values, considering a vast majority of us will be going into law firms and sort of holding true to those values at the firm outside of doing like firm-sponsored pro bono.
Totally, I was kind of reflecting on my path, and I think it starts with the people, kind of making choices to the extent it's gotta be so hard to find a job these days, but making choices to the extent we can about the people that we're working for and people that we respect and admire and who share our values. And even if I started out in bankruptcy at Alston & Bird in Atlanta, and partly because I just loved the person who was running that department, but then went into doing M&A at King & Spalding in New York, and I was doing an acquisition for a paper company, and I was like, this doesn't feel very good. So just kind of kept making shifts incrementally and moved in-house to a company called Razorfish, where the very first day was a big sales meeting, and the CEO walked out to the middle of the floor to the song "I'm Too Sexy." Okay, this is also maybe not going to be totally aligned. But then went to Levi's and was able to kind of really, that was, privately owned through 8 generations. I think just taking it one step at a time and knowing that you've got a long career ahead of you and you can still do tons of good. I mean, these guys are doing, I'm sure, amazing things every day through private practice. And I do think the decision-making in even traditional corporate practice has evolved to really kind of thinking about more than just how do we maximize the value out of this deal. And you all can be the change too in that world. It's so exciting that there's so much opportunity. I really do think that the kind of old traditional corporate models are just not going to be what takes us into the future.
Do you think in bankruptcy it'll ever deviate from the traditional model?
That was 27 years ago, maybe. I don't even remember anything about that practice. And you'll find that you probably, I can't even remember what classes I took in law school, to be honest, except for torts with Leavenworth. Did anybody have Leavenworth or torts? So I don't know. It's a good question. I don't know how that field is evolving. Are you taking that class?
Well, yeah. I mean, I'm going to bankruptcy, and I've written some responses for Professor Barzuza about how the whole ESG thing, I just don't see how it's reconcilable with, in bankruptcy, when things start going bad, like all of a sudden it's like only people care about money.
Yeah.
And I was just reflecting on like what you were talking about, like Patagonia, you're very blessed to be at a very successful company. And so I don't know if every company can have this model when Patagonia is like one of the most successful companies out there. So I don't know, that's just what I was thinking about.
I mean, that's kind of why we need to make sure this works, for one thing, this new model. But also, I think, even if it's not to this extreme, just for any company, if they just have a clear, I think maybe one of you said this earlier, like really clear about the company's values, whatever they might be, clear about the mission, and then it just, that I think is really like the North Star, and any company can do that. I mean, it's harder to do that when you haven't started there. So even if, there's no world in which everybody's going to kind of be as extreme as these are kind of visionary people that are one of a kind. But I think the values and the mission is part of everything.
So I want to ask one more question. So what did you do in the past to promote diversity? And has it become more challenging now as a result of the Supreme Court decision? Do you guys get different advice?
No, I mean, we would just do what we do on that. And
what do you do?
That? Oh, well, we actually have a whole program of, we're not reporting on demographics or that kind of thing right now. We do pay equity audits every year. We do a lot of programmatic things. We put a lot of programmatic, really just internal programs in place that make it more clear about removing bias from promotions, from pay decisions. We have a recruiting policy that takes a little bit longer, but that brings in a lot more candidates from different demographic groups. We're in an area where we don't necessarily have a very diverse population in Ventura, California. But our retail stores are in, places all over the country, but I don't think we would be worried about the kind of the legal side of coming after us for that.
Well, thank you so much. That was fascinating. We learned a lot, and just keep doing what you're doing.
I feel like it's so intense.